Glendorf. We have numerous of attorneys in the audience. We got the attorney Jim Bone, and we got, he's not an attorney, Darrell Noble, but possible. We also have attorney Patrick Merkel, attorney Robin Ryan. We got Bob Weaver, president of the Tennessee Automotive Association. And we do have some commissioners with us this morning, also Kevin Culler. And let's see who else. We have Ronnie Fox, Commissioner Ronnie Fox back there, I believe I see him. And we have Commissioner Lynn Webb. Welcome and good morning. We're running behind schedule. It's about 9:20 a.m., so I believe that we do have a quorum for the legal report. So we're going to turn the meeting over now at this present time to Attorney Anthony.
Is this being recorded? Okay. Good morning. This morning the legal report is pretty substantial. It being the length that it is, I'm going to change the way that I've normally presented it to the committee by basically I'm going to highlight the more substantial cases for the committee so that we can I can inform you of those and we can speak of them if you'd like. If you have some that you would like to review, then when I finish we can bring those up and speak of those also. This report is actually too long to be read within the allotted hour and a half that we had. So what we'll do is in the commission meeting when it's voted upon and all of that, what we'll do is we'll attach it to the minutes for next meeting for the approval of the minutes. That way the entire report will be there, so everybody will have it. But I'll start out with, and I'll tell you the numbers that I'm going to go by, not page numbers, but actual the numbers to the left of the cases when we go through that. We'll start off with number one. Here, this is a dealer who had a notice of violation for unlicensed activity, and what he did was he had an empty lot behind his dealership, and he purchased that lot and he started advertising vehicles on that lot. Because it was also facing a different street, and he did not have a license, and it was at a different physical location. So we had an investigator go out there and speak with him about that, and we took photographs of the vehicles that were there, but it was an unknown number of actual vehicles that were being advertised that belonged to the dealership. So the recommendation here is authorization for a civil penalty in an amount of $2,000.
Comment from the commission? It's okay.
Next is number 18. It's on our page numbers are probably different. This is case number 2012010881. Here, the complaint here was a consumer who alleged that there was misrepresentation on the branding of a title that was delivered to them by a dealer. The complaint alleged that they received a rebuilt title and they were promised an unbranded title. We conducted an investigation, and I also received information from the Department of Revenue to be able to determine what happened. And the title that the respondent had at the time of the sale, the title that the dealer had, was a Kentucky title that was an unbranded title. When he gave that title and sold the vehicle to the consumer went to register the vehicle, and a branded title came back as a rebuilt, where the vehicle had been previously salvaged. I talked with the Department of Revenue and Vehicle Titling Services, and it showed that the vehicle had previously been registered in Tennessee before it went to Kentucky and actually had a rebuilt title. When it went to Kentucky, that's where the clerk there made a mistake on their titling, and they titled it as an unbranded vehicle. So when this dealer purchased it, and it looked at the time that the time that he purchased that vehicle to the time he sold it was not a significant amount of time. And during our investigation, he indicated that he attempted to get the vehicle back for the full purchase price from the consumer, but they didn't want that. So, given that, I recommend that we close this with a letter of warning regarding the titling. And that there actually wasn't any intent of misrepresentation on part of the dealer. Next is number 31. 31, and the case number that you have there is 2010-01871. And I would like to make a notation that that case number is actually incorrect, and I have the correct case number. It should be 2012-018701. Here, a complainant consumer alleged that the respondent dealer had rolled back or lied regarding the miles on a vehicle purchased. Investigation was conducted. The dealer purchased the vehicle wholesale from another Tennessee dealer, the vehicle having 205,000 miles on it. The previous Tennessee dealer purchased the vehicle as a trade-in from a consumer, and when that other dealer purchased it, it also had 205,000 miles on it. The complainant purchased the vehicle from the respondent with the 205,000 miles, but when they took it to have it serviced and had the an OBD2 onboard diagnostics hooked up to the vehicle, it indicated that the vehicle had over 500,000 miles on it. The Carfax that we were provided did not indicate a mileage discrepancy. The vehicle was built in 1998. There's actually no proof that the respondent knew that there was a discrepancy in the mileage. Therefore, I would recommend that we close this with insufficient proof that the odometer had been rolled back or altered by this respondent, in this case, by this dealer. Next case. Number 66. And on this case, I've listed out several dates here because the dates, the sequence of the dates are important. This is case number 2012020781. This was an internal complaint that was opened by an investigator regarding allegations of fraudulently titling of a vehicle. Investigation was conducted. The investigation found these things on these certain dates. On June 10th of this year, there was a bill of sale that indicated the respondent sold a 1998 camper, recreational vehicle, to a purchaser one, indicating that a trade-in from the consumer for 2007 year 2000 Chevy. The Chevrolet title was not noted on the trade-in at the time. At the time of the sale, purchaser one was not indicated on the title. On June 28th, the title on the recreational vehicle indicates that the respondent purchased the 1998 camper from the seller. The respondent is listed as the lien holder on the title of the camper. On July 2nd, the registered owner of the 2000 Chevy applies to the Department of Revenue for a duplicate title. On July 16th, the camper sold to purchaser one, sold by purchaser one to purchaser two via Craigslist. On July 27th, the respondent, and this is where the dates start to get not to make sense, the respondent sells the 2000 Chevy bill of sale to an insurance company. And after July 2012, the respondent places the name of purchaser two on title in lieu of purchaser one. And on September 2012, the Department of Revenue makes the respondent apply for the right title. What happened specifically, to make it a little bit less complicated, is that it seemed that the dealer basically sold a camper or a recreational vehicle there's a third party involved who actually used the dealer to allow his name to skip the title and to not pay taxes, and then to sell it to another third party, and then it didn't have that seller, the person he purchased it from, name on the title either. Due to this, there's a false listing of the 2000 Chevy as a trade-in from purchaser one, without her receiving title ownership, by placing the purchaser two on the title of the camper and skipping the chain of title, which was very significant. I recommended an authorization for a civil penalty in the amount of $3,000, $1,000 for each three acts that we found there. Number 72. Next would be number 72. Number 72 is case number 2012016761. Here, a notice of violation was issued to the respondent dealer during a biannual inspection, where it was found that multiple temporary tag log violations occurred by issuing temp tags, more temp tags than allowed to customers. it was found that respondent had 127 such violations. On 110 occasions, a third temp tag was issued to a customer. On 16 of these occasions, a fourth temp tag was issued to a customer, and on one occasion, a fifth temp tag was issued to a customer. The respondent has been in business since 2011, so it's a new company. The respondent replied through its attorney stating that they failed to properly manage the number of temp tags provided to customers. To correct the problem, the respondent hired an experienced general manager along with an experienced title tag clerk. The respondent is a high-volume dealer. They've issued over 1,400 temporary tags during that period. They state that the 127 violations that they had was due to their inability to register titles to the vehicles within 60 days, and this equated to basically 10% of their tags issued. They had problems issuing them within the 60 days. There's no evidence on the record that we had of any fraud or sales tax violations on these vehicles and that they were eventually registered, but they were. This office, my office, made contact with their attorney and the respondent. The respondent generally agreed to pay a civil penalty in the amount of $31,000, which was suggested by my office after looking at these. And I would recommend authorization to agree to that, to recommend authorization of $31,000, which would be 110 counts of a third temp tag at $200 per tag, which was equal $22,000, 16 counts that they had of the fourth temp tag issuance at $500 per tag, equaling $8,000. And there was one count of a fifth temp tag being issued at $1,000 for that tag, for this to be settled by consent order or formal hearing.
What's the total amount?
$31,000.
Any more questions, comments?
Number 89. Next would be number 89. There's two cases here. Case number 2012022831 and 2012018991. Here the respondent dealer has failed to provide titles to consumers in these two cases. An investigation found that the respondent had abandoned its established place of business. The commission we already have 3 other such matters pending. The respondent's bond was canceled and it's been canceled, and respondent's license does not expire until 2013. Given that we have 3 other cases that are already pending, and I believe for formal hearings, for authorization for formal hearings, I would recommend to be able to have the authorization for the suspension of their dealer's license to be settled by voluntary surrender or formal hearing if necessary. And what we would do is we would roll these up and meet with the other cases also. The next one would be number 91. Number 91. This is case number 2012015001. And without having to read all of that, I can explain it because I haven't. I remember this one is specifically. This is a public automobile auction who took a vehicle, 2005 Ford, and they listed it on their to be auctioned off. They received the vehicle roughly between 3 to 4 days prior to it being auctioned off, and the advertisement showed that it was a four-wheel drive 2005 Ford, and it indicated its VIN number. After it was purchased, the complainant alleged misrepresentation on part of the auction, stating that the four-wheel drive did not work. They specifically said that the four-wheel drive was actually not part of the vehicle and it could not work. We had an investigator conduct an investigation along with the Department of Revenue and found that the vehicle that was sold to him at the auction, which indicated that it was four-wheel drive, the VIN number that came off the body was actually a two-wheel drive vehicle. There was a separate VIN on the chassis, which came back as a four-wheel drive vehicle. But the four-wheel drive components actually did not work, and they weren't the original four-wheel drive components. The Department of Revenue indicated that this vehicle should have been titled as rebuilt prior to it being sold to the consumer. The auction has stated that they have done nothing wrong, that they listed the vehicle exactly as it came to them. However, our public automobile auction statutes indicate that public automobile auctioneers will have the same duties and responsibilities as motor vehicle dealers because they are licensed as motor vehicle dealers. Because there were two separate VIN numbers, they should have had two separate VIN numbers indicated to the consumer at the time of purchase. There is a material defect on the vehicle, in my opinion, and the price of the vehicle does not disclose that, which they purchased it at. I'd recommend an authorization for a civil penalty in the amount of $1,000.
Okay.
Next, number 96. I would like to pay particular attention to number 96. Number 96 is case number 2012004841 and 2012026884. Here the complaint was submitted alleging that a respondent dealer was conducting unlicensed activity by displaying motor vehicles in a shopping mall as a dedicated storefront. An investigation was conducted. The respondent has a licensed location for its dealership other than the mall. The respondent also has a store located inside the mall where its vehicles are displayed. The vehicles are parked inside the store, not in the mall's common area. The respondent has employees representatives available to answer questions regarding these vehicles. The respondent indicated that the employees are not licensed motor vehicle salespersons. They do not make sales at that location, and they direct interested customers at the dealership location. The mall is not licensed as a location. Under the Commission's rules, the display of motor vehicles at a location other than the licensed location where a representative is available to answer questions can only be done so by first obtaining a show permit and is only good for 7 days on a one-time renewal. The rule also states that the dealer may display at a single location without obtaining a show permit, provides that 1, there's no representatives at the dealership, that one of the approved locations is in the interior of common areas of the shopping mall, whereas here the vehicles are not in the common area of the shopping mall, they're actually at a dedicated storefront. And representatives are acting on behalf of the dealership, and the vehicles are not just being displayed. The fact that they're not in a common area, they're actually in a private storefront location being displayed. My recommendation is an authorization for a civil penalty in the amount of $5,000 and an order to cease and desist. What I wanted the committee to understand is that this is an actual dealer who has a lease at a storefront. He actually has vehicles in the storefront with his dealership sign on the storefront in the mall, but these vehicles are actually they're actually in the storefront. It's not how the rule contemplates where you have just the vehicle sitting in the mall, where you just go park your vehicle and it just sits there. He has actual representatives, people that he pays to show potential customers about these vehicles. And if they don't attempt to sell this vehicle, they send them to the other location, to the actual storefront location. This complaint came in, I believe, in July. We've done an investigation. We're presenting it now, but authorization of this would mean that we would send out an order requiring them to cease and desist from that activity. Case number 104.
What's the number?
Case number 104. The actual case number is 2012019131. Here the complainant, who is the owner of a vehicle, not a purchased vehicle, owner of a vehicle, alleged fraud on a part of a respondent dealer regarding the notarization of a power of attorney presented to the owner of the dealership. An investigation was conducted. The investigator found that the respondent, who is the sole proprietor of the dealership, was requested by customer A, which is called customer A, it was a female, to notarize a power of attorney to allow her to conduct transactions for the sale of a motor vehicle owned by customer B. Customer B was the gentleman standing next to her. So she came to the dealer and said, will you notarize this power of attorney that will let me sell this guy's vehicle? Customer B wasn't actually customer B. It wasn't actually him. Okay. So customer B was not in fact that person. No, he wasn't the owner of the vehicle. He wasn't actually customer B. The respondent didn't know this at the time. Our investigation indicated that the respondent was actually did not know these people when they first came up. The owner of the vehicle, customer B actually didn't have a driver's license either. So they came to him for, will you notarize him? Well, he doesn't. He does not have a driver's license. So the respondent was hesitant, but he went ahead and notarized. To allow her to sell the vehicle. Actually, after we did the investigation, we realized that he wasn't actually the notary. The dealer wasn't actually the notary. It was his mother's notary stamp. So he actually signed her name for her, forged her name on that. Well, customer A, who got the power of attorney, actually went out, got a duplicate title to the vehicle, put it in her name. She put it in her name, and then she went to Title Max and got a lien against it for about $3,000. Now, the person who all this was against, he actually went to court and received his vehicle back, and he has sued the lady who I believe was his niece. The whole time, the respondent, the dealer here, has claimed that they actually were customers at the time. They were trying to buy a vehicle. They didn't buy a vehicle. He claims personal responsibility for the action. He claims responsibility. He believes that he was defrauded by these people, but for some reason he thinks that using his mother's notary wasn't that big of a deal, signing her name. But I believe here that he understood what he did wrong, and he was apologetic for it. I recommend authorization for a civil penalty in the amount of $5,000.
Okay.
Case number 105. Number 105. Number 105. Case numbers 2012-019-022, 2012-019-021. Here, an anonymous complaint was received alleging unlicensed activity on part of Respondent 1. An investigation was conducted. There's going to be two respondents. An investigation was conducted and found that Respondent 1 had a website advertising vehicles for sale as a vehicle brokerage dealership. Not licensed. The name does not have a license. It was found that the purported point of contact seller for the website was a licensed salesperson for Respondent 2. So this website, unlicensed, the person's name, he is a salesperson, licensed salesperson for an actual Respondent 2 dealer. Respondent 2 dealer is a sole proprietorship and he has a joint account with the salesperson, allowing that salesperson to purchase vehicles at the auction. The salesperson then places these vehicles on its website under the name of Respondent 2. So the salesperson buys vehicles at the auction with authorization of the dealer, and then he puts them on this website that has a different name than the dealership, and that dealership is not licensed. The bill of sale and title work is then done under the actual licensed dealership name. So we did an investigation, and basically what they said was that we want to separate the dealership that we actually work under. This license sells kind of cheap cars, and this website that we have sells expensive cars. Now, all the title work is done through the dealership, but when you go on the website, you actually have a name that is not licensed. Well, when our investigator went out there, we had him go out there undercover, and all of these cars are actually at a warehouse next to the salesman's personal residence. And he went up there and said, "Can I buy one of these vehicles?" And an unlicensed person who was standing around there said, "Yeah, we can sell you that car right there." So when we first started, we said, well, this is a completely unlicensed dealership, but what we found is that the salesman is actually titling the vehicles to an actual dealership. Now, the vehicles are actually purchased through the joint account of the dealership, so they seem to be owned by the dealership. They seem to be, but the fact that he actually has a website, the unlicensed salesperson at the warehouse actually had a business card as a salesperson under that false name. And the fact that you could actually buy that vehicle from him and never know that you bought it at a dealership. So instead of this being an advertising problem solely, we looked at it and saw that there was actually an attempt to make an unlicensed dealership here, unlicensed activity. Now what they have done is remove the name of that dealership, that unlicensed dealership, from their advertising. And I recommend that each of these respondents, we do civil penalty for the amount of $10,000 to each of them. One is to the ownership of the actual dealer, the owner of the dealership who actually knew that this was going on, and then to the salesperson. The salesperson having conducted unlicensed activity, the dealership having conducted, also engaged, since he is a sole proprietor, unlicensed activity and advertising violations. Next will be case, it's number 109. It's case number 2012-005161, 2012-008941, 2012-003142, and 2012-003141. Without reading it, I can explain this one better. These are unusual for us, these types of complaints to receive, but this is a complaint against a distributor manufacturer, and this person is licensed, and what he does is he buys chassis from other manufacturers, distributors, and he makes FedEx vehicles. He makes little FedEx vans. So he buys a chassis somewhere and he sends it off to a place in Indiana, and they put a cab on it, and then they send it back to him. Well, our statute says that a manufacturer distributor cannot sell vehicles to consumers. They cannot compete with dealers. They have to sell them through dealers. So these allegations, we had 3 complaints from these consumers complaining about not being able to get a title for their vehicle, which it made sense in the end because we realized that he's going through all of these other, he's actually going through other dealerships to purchase these frames for the first item. And so the title work had been, I say messed up several times because they could not sell a new vehicle to these people. And people in the audience will probably understand what we talk about. We say they have difficulty selling them as new because they've been brand titled before. It seems that he is close to correcting his problem. We didn't go into the depths of his exact business venture because that would probably be for his own attorney to figure out. But in this case, he actually did sell to these individuals 3 vehicles. All but one has received their title work and they're satisfied with it right now. And the one is actually in process of being worked. It's just taken over, I believe, 6 months for some of these people to get their titles. I recommended that for each of these that the commissioner authorized civil penalty and a total being $12,000, $4,000 for each sale to a non-dealer to be settled by a consent order or formal hearing. Because this is the exact issue that goes into when they sell it to an individual. They get into these titling issues, and then they can't actually conduct business with a vehicle that they purchased for business. I would go next. I'd like to go to the representations. We don't have many of them. And then Ms. Robin Ryan will actually have 3 that she would like to present to you when I get done with the representations, and then that will be, we'll finish that up for, that'll be finished for the review committee. Number 112, this is case number 2012-005671. Here there was a previous authorization for a consent order in the amount of $32,000 for the respondent for failing to account for 2 dealer tags and for failing to properly maintain his temp tag law. The dealer contested the citation, providing a police report indicating the missing dealer plates were stolen from the parking lot. Further, the respondent came to the Motor Vehicle Commission on two occasions to discuss their temporary tag log issue. The respondent indicated the temporary tags were used to transport their own purchased vehicles from other states to Tennessee, which it's allowed under the Department of Revenue rule, and that rule is stated in there. The respondent had not recorded these tags on their log, indicating they didn't believe that these tags were actually what they would consider to be issued at the time. This is the first time that I've ever encountered where a dealership has said, well, we didn't write them down because they were issued to us, and we didn't see where we would need to do that. Given that, I'd recommend to amend the previous authorization to the amount of $500 for the mistake, but not the mistake that there was actually some kind of harm or potential harm that had to do with sales tax revenue evasion by not indicating these tags on the temporary tag log.
How did he get the tags?
He's a dealer. He's a dealer.
So he went to the state and bought the tags.
Yes, he went to the state. He bought the tags. And dealers.
How could he think they were issued to him?
Say that one more time.
How could he think they were issued to him?
He did not write them down on his temporary tag log because he did not believe that he was issuing them to customers. he did not believe he was issuing to a customer, so he did not believe that when he was using them himself, he did not believe he needed to write those down on that temporary tag log being issued to customers. Now, if anybody has a suggestion about another civil penalty or amount, I'm completely open. This is just my take on.
How was he
on
using
that.
them? I'm confused.
He was using them when he was buying vehicles out of state to transport them back to
Instead of
Tennessee.
using dealer tags.
Is that legal?
It's allowed under the under Department of Revenue rules. They're allowed to be used by dealers. The dealer can use his own tag. Whether or not it's legal to use a Tennessee temporary tag in another state to transport down here, that's beyond the scope of the legal review that I do.
It's a tag.
So it's okay to use a temporary tag to get a car from take out of state back in?
I don't know if it's legal. I'm not looking at whether or not it's legal to use a Tennessee temporary tag from one state to another. What the issue that I was looking at was whether or not he is required to actually indicate on that temporary tag log that he issued a tag to himself.
And he
And not
used-
that he's not required to. There's still a civil penalty involved. The recommendation here is $500. It was previously at $32,000. But when the dealer came back and we said, well, where did the dealer said, these temporary tags, I didn't issue them to customers. I didn't issue them to customers. They were issued to myself to transport my own vehicles back. And I'm glad that you all didn't have these discussions here, because I'm sort of perplexed at times as to whether or not this is a mitigating factor that the review committee thinks that is adequate enough.
Well, maybe I don't understand the law. I didn't know that I could issue one to myself and go drive a car
Yes.
and then put it back and sell it to somebody else.
No.
No?
Not the tag.
Can he fill them out?
Yes, he did fill them out. There's not a question that he did not fill it out.
He just didn't record it.
He didn't record it on his temporary tag log.
I think the fine makes perfect sense to me. I mean, if you're going to issue it to yourself, you still have to fill that out because you've issued it to yourself.
Right.
Just doesn't, I mean, it's for use.
And our statute says, the statute of the Motor Vehicle Commission says that you shall maintain a temporary tag log for the issuance of tags. And it says that specifically. It doesn't say exactly, it doesn't go into any other detail. Our statute just says you shall maintain a temporary tag log. It has no other detail. The Department of Revenue has rules as to the detail that dealers should keep their tags. But we're not the Department of Revenue. Their laws and their rules are their laws and their rules, and they're the ones who enforce theirs. Given that our statute didn't go into any more specifics, and this was his reason, and that he is allowed to use them for his own purpose by the Department of Revenue. That's why I said there should be a civil penalty involved to make a learning point to him, to make sure that it doesn't happen again, that he does maintain his record. But the amount that was originally authorized, which that was not I did not make the original recommendation to you all. That was not me who recommended that. That was prior to me getting back. But I'm the one who saw where the response back was, we issued these to ourselves.
The 250 for each.
So if you stayed with a $500 penalty, that's normally assessed per tag.
250.
No, that's not the amount. The amount that's normally assessed per tag is generally for the first violation, we get $500 per tag. Now, I say this is that our statutes specifically say that you cannot, that if you issue more than 2 temp tags per customer, that's a violation.
Right.
Now I say that's a violation each time. So that's if you issue the third one, that's a violation. If you issue the fourth one, that's a violation. That's 2 violations. You can do that at $500 a piece. Now our statute on recording temporary tags, it just says that you shall maintain a log for the issuance of tags. It does not say you specifically must indicate every tag that you issue. It doesn't specifically say that you must put down their name, the date, the VIN number, the make, the model. It doesn't say that. Our statute is a little bit silent on that. So it's good to know with the review committee how they would like to interpret that, because it helps me going forward.
I assume that, this Commissioner Jackson, I assume that when we arrived at the 32,000, I can't remember, but evidently we must have looked at all those cars that he brought back, or whatever the report showed at the time that we looked at it. I guess we did $500 times how many?
Right.
Yeah. And that's how we probably arrived at
It was probably, yeah, the 32,000 probably, more than likely, and I can get the file, probably came from 64 counts of not indicating that tag on there. Probably what it was.
Yeah, and then the dealer tax.
Well, if you feel like you're not establishing some precedence, I'll acquiesce and say that, okay, you do as you got it done. But I hope we're not doing I'm surprised that you can use drive-out tags to go pick up cars.
The Department of Revenue rule specifically says that dealers can issue tags to themselves. That they can.
Yeah.
They can use their own temp tags. They can issue them to themselves. They can actually issue them, to other dealers. One dealer can issue it to another dealer, and the revenue rule specifically says if a dealer issues it to another dealer, they must maintain that accountability. They must write that down. That's specific in their rule. But they don't have a specific revenue themselves. Don't have a specific rule that says that specifically if a dealer issues it to himself, he must write that down.
Well, that's part of maintaining the tag log.
So, because our rules does not specifically specify exactly, what you write down in this log, well, here I've got a dealer who's been using them himself, and we don't have anything indicating that he's lying to us about that.
But you don't have any reason to think that he's not because he didn't put them in his log.
That he didn't issue them to customers?
Right.
Right.
Well, I only go by the facts that I have in front of me. What I don't do is try to read into facts, because that makes that puts me in a position of not giving you all actual facts. And
Yeah,
I'm just
I
reading
understand.
into it. If you all can read in however you would like, but what I'm giving you is what I was indicated.
See, it's kind of hard to keep up with tags. I do understand that. It's a problem. It just seems to me like this is a pretty low fine for what's
Well, and I think
what's happened here.
if as a committee as a whole, if you all believe that I've done something that's much less than, and I mean, you can reject it, or you can make a proposal for a different amount if you all think that there's a different amount would be better.
Well, let me ask, what would be the normal fine if you went in and some dealer says, well, I'm not sure what I did with these tags, and there's 10 of them, what would you do?
Well, normally, if you have a temp tag log that's not specifically maintained, where you have tags that are not indicated, I generally, and I'll tell you why, I generally recommend to the commission that there is a flat $1,000 civil penalty. And here's the reason why. Because before last year, there was no way for the Motor Vehicle Commission to really know how many tags a dealer had bought. Last year, the Department of Revenue let the Motor Vehicle Commission have access to their database, which says exactly how many tags were issued. So when we had an investigator go out there, they could have, if you bought 900 tags, that investigator would go out there and say, well, see your log, it's got all these 900 tags. And before last year, we couldn't do that. Now, since then, we have been disconnected from the Department of Revenue on that. They've had an issue with that. But their database actually has an issue. We can't see them anymore. So we don't know. So in the past, before we had ability to see how many tags, if we knew that you were missing tags because they were being skipped, we just did I would recommend a flat $1,000, because I didn't know how many there were. I had no idea, no way to come up with the certain counts. Because this database came out, we could actually see you're missing 64 tags. And generally the commission has done $500 a piece. So that's $32,000 is the amount. That's how that initially came. The 1,000. Short answer.
I'll accept what you got, but I think it ought to be 1,000 because of what you do on the other case.
Okay.
I'm with you, I think $1,000.
Okay. Let's make that change.
I'm with Commissioner Clayton.
Thank you, Susan.
And I do appreciate the discussion because that does help me sit in my office, not have to think so hard. Thank you. Okay. The next few are going to be fairly quick here. Number 113, that's case number 2009-004071. It's a representation. This was previously authorized to revoke the salesperson's license. This person has actually let their license expire, and so there's no license that can be revoked any longer. I would recommend that we close and flag this. Number 114, that's case number 2011002911. Here there is a civil penalty for an amount of $500 for a business failing to renew its city and county business license. Similarly, this dealership has let its license expire and go out of business. I would recommend that we close and flag that case. Number 115, 2011025191. Here the commission previously authorized $2,000 civil penalty for unlicensed activity on part of the respondent. The respondent decided is incorrect. The investigation found that the individual has sold the vehicle. This person was employed by a respondent but has since been fired. So this actually is this was against an individual. There's no proof to actually sustain it against this respondent. This respondent was actually a dealer, and this was somebody who worked for a dealership who was acting on their own. I would recommend that we amend that previous authorization to close that for insufficient evidence of violation on the respondent, the dealer. Number 116, that's case number 20100215552. Commission previously authorized civil penalty amount of $1,000 against the respondent for issuing a third temp tag to a consumer. The respondent has since gone out of business, is no longer licensed by the commission. I recommend that we close and flag this one. The respondent is out of business, no longer licensed. And case number 117, the next one, case number 2011003081. Here the commission previously authorized a civil penalty in amount of $2,500 for what was presented to you was he sold a frame damaged vehicle without disclosing. Upon further review of the file, the documents provided from the respondent and me speaking with their attorney found that there was no evidence of actually sustaining frame damage on the vehicle that jeopardized the integrity of the vehicle. This vehicle that was sold was actually announced at auction as having unibody damage, which the respondent indicated was damage to the passenger side door. A review of the Carfax then and actually currently now, if you review it, there's no accident ever reported on that vehicle. The respondent provided documentation showing that no adjustments were made to the vehicle's support structure, that there was only a cosmetic repair on the door. However, the respondent at the time did have a printout that indicated that the vehicle, the respondent at that time of the sale did print out and present an auto report which did not list the vehicle's announced condition at the auction. So when they sold it, they printed out the report, and it didn't have that it was announced at auction as unibody damage on there, probably because it just happened at auction and it takes some time for those to catch up on the report. But the commission previously looked at this and said you sold a vehicle with frame damage and you didn't disclose that there was frame damage, and they did a $2,500 civil penalty. Going back at it now, and this issue has cropped up over the years, and it becomes more often where if the vehicle has something happen to it, such as like a dent in the door on a certain part of the frame, they'll actually indicate that it's unibody damage because that vehicle doesn't have you'll understand, it has a unibody frame. And in this instance, the vehicle repair orders that we have on it does not actually show that there's actually anything wrong with the integrity of the vehicle. So I believe a civil penalty is warranted for not telling the person that there was some kind of damage to the vehicle because it was announced at auction that there was a damage to the vehicle, so the dealer knew it. But it's not the type of damage such as traditional frame damage that would warrant that amount of civil penalty. I would recommend that the authorization be amended to amend $1,000. And then Ms.
Do you want to go to the other ones for probably mine or not? Or are you not going to do them first?
I'll let you do these 118, 119 are yours. And then Ms. Ryan's going to speak of 118 and 119.
Good morning. I'm the litigation attorney for this particular program, and the cases that I'm going to be representing to you this morning are cases that were presented to me for litigation. And this is why they're being represented. This first one, 118, case number 2011-029791, was originally presented in April. Now I'm going to read the entire original presentation and then what we have discussed since then because it is pertinent to the particular issues at hand. This complaint arose as a result of a new dealership inspection of the business premises of respondent on or about November 14, 2011. They were then issued a notice of violation for unlicensed activity for selling 252 cars on an expired license. The dealer was aware the dealership license had expired in 2011. During the inspection, it was found that after checking the temporary tag log and the sale analysis report, that from August 2011 to November 2011, they had sold 252 vehicles. They could not offer any explanation why the license was not confirmed or renewed, but did confirm the sales. As a result of all of that, the respondent was issued a agreed citation amount of $126,000 for 252 counts of unlicensed activity. That was then the recommendation and then be settled by a formal hearing. This was referred to me in litigation and was originally set for October 2012, but we continued the matter December 14, 2012. After review for litigation and a full history review, the respondent apparently attempted to renew the license timely, but was mistakenly told that due to being incorporated, which occurred in 1995, a new license had to be issued, and this caused delays. Reviews show that the license should have been renewed with the new status, and that respondent had a surety bond in place for all but the first 3 days after the expiration date, but within the granted 90-day grace period, which you grant to all licensees. Respondent paid both the renewal and then a new license fee, and a review of the file reveals 4 cars sold in that 3-day period without a surety bond. Attorneys for the respondent and myself then reviewed the entire issue and have agreed that he should be cited for the cars sold minus the redundant license fee. So the new recommendation is it's going to be a civil penalty in the amount of $1,600 by virtue of an agreed order between the attorneys for the respondent and us. Do I have any questions about that one? Okay. Another matter that was originally presented in April 2012, again, it was originally presented to me as being in litigation. This complaint was internally generated, alleging the respondent, who's not licensed as a motor vehicle dealer, had a detail shop and was selling vehicles in front of the business. It was alleged that respondent was selling vehicles through a dealer in Georgia, and the Georgia dealer holds the titles. Complainant alleged there were 2 to 3 vehicles parked outside the fence, 8 to 16 vehicles parked inside the fence at the location. This activity is alleged to have been occurring for several years. The vehicles allegedly have for sale signs in the windows and prices listed on the vehicles. During an investigation, respondent admitted to offering friends' vehicles for sale on the property. Investigator noted 11 vehicles displayed in a for sale manner on the respondent's property during the investigation. A respondent admitted he had on occasion sold vehicles in the past, but there's no proof just how many in the investigation report. Respondent was informed that can only sell 5 vehicles per year that are titled his personal name and could not offer vehicles for sale on behalf of another individual without first applying for a motor vehicle license. The original authorization was for a civil penalty of $500 as for curbstoning. Again, this was referred to me and I reviewed it. The consent order was turned as unclaimed. In reviewing the investigation, it appears that the business had cars parked, but only one had a for sale sign. Most were on the property and owned and being sold by the individual owners. No cars were owned by any dealer, and the property's owner's main business is in detailing cars and doing minor repairs. A review of the law follows with no license is required if you are allowing another to sell their own vehicle on your property. There is no legal definition of curbstoning and no Tennessee laws prohibiting the behavior described in this particular case. So my recommendation at this point is to dismiss the pending complaint. Anybody have any questions?
Sounds like you got a choice, doesn't it?
Well, you have a choice, certainly, but there is, but as far as a legal hearing on it, We don't have the law to support the activity that's being complained of. But you certainly can go ahead and have a hearing on it. It's just my recommendation that this would not be a good one to go forward on.
Okay.
So, you want to do the rest of yours, or do you want me to do mine?
Oh, no, the last one. You did that.
I have one more today that you do not have in front of you, but I do have a summary for you.
This was brought in, I guess, Friday morning, Friday afternoon, so it actually could not get on the legal report or the tablets as we have there, so.
And the reason is because this was the matter that was going to be heard tomorrow at a full hearing. I don't have the number of the file on it, I'm sorry to say, but I will amend it and produce for the record the file numbers for this particular case, because I did not put that at the top. This complaint was generated as a result of routine inspection of business premises respondent on or about December 13, 2001. You don't have the file number. We're in multiple very serious violations of illegal activity recovered. Such violations consisted of expired city and county business licenses, signage issues, temporary tag misuse, temporary tag log violations, sales and open titles, possible sales fraud. Respondent selling vehicles in salvage title, failure to maintain business records, etc. Subsequently, an investigation of respondent was conducted by a team of investigators from both this office and the Department of Revenue on or about March 1, 2012. The investigation provided evidence of 165 temporary tag logs, 145 vehicles sold prior to being rebuilt, 12 instances of misuse of dealer plates, 172 open titles, 17 excessive temporary tags being issued to customers, 3 vehicles with no titles, 1 illegal possession of a vehicle, 12 salvage certificates, expired business license, and no hours posted. The civil penalty for such numerous violations could add up to an amount of $378,500. This committee authorized for a formal hearing without a consent order to pursue the revocation, and that was the recommendation, and a civil penalty. But what this committee authorized was a summary suspension to pursue the revocation of the motor vehicle license. This summary suspension hearing was scheduled for August, but respondent and his attorney agreed to continue the matter for a full hearing. After full review of all the documents and all the facts, it was determined that there were a total of 75 excess temporary tags and 65 open titles. The employee who was responsible for the daily operations and who issued the illegal tags was subsequently arrested and pled guilty to violations of the Department of Revenue and has not worked at Respondent's business since that time. Respondent's business has been suspended since August and they have not been in operation. What the attorney and I have discussed and would be a civil penalty for the violations we can find, that are the excess temporary tags and the open titles, in the amount of $70,000 and payment of the port costs, and a provision would be in the agreed order that if the $70,000 was not paid by January 14th of this year, the license would be automatically revoked. You're going to wonder why it went from such a big thing to such a little thing, and let me explain that. The investigators found violations maybe of the Department of Revenue, but not of our laws. We cannot cite or fine them for that. And one more important thing, as an aside, these particular individual who was truly responsible for this had been doing this in an attempt to really put this person out of business because he was going to be a partner of another dealer. Yes. And it was, and they recognized their responsibility, which is why they were willing to pay the $70,000. But the actions were a part of this particular individual, and his license was not accepted or by this commission, or by this group, so he has no license. He has been arrested for fraud in all of his activities in this particular matter.
Get the money.
Get the money.
Yeah.
That'll conclude the legal report on behalf of the legal counsel.
May I regress a little on one of the reports? Ms. Ryan, on number 119, case number 2011025-821.
Just a moment. I'm sorry, just a moment, let me find it. Okay.
The interpretation in the last paragraph of that case number is a little troubling to me. I'm not certain that in a legal review, there should be an interpretation of the law on the record. If this complainant is out of business and it's impractical to collect, I'm concerned about stating that there is no law against curb stoning. I'm afraid that opens up a real...
What I said was, there's no legal definition of curb stoning. That's what I said in this particular
Well, I agree
report.
with
And
that.
there is no legal definition of curb stoning. Now, you all can ask and make a legal definition for that, but we don't have one. It's a practice that's recognized and interpreted differently by various parts of the country. We in Tennessee, which is what it was set for in the first place, was a formal hearing on curb stoning, which is why I had to address it in my review of it. There is no legal definition for it. But regardless of whether there is or not, what this person was doing was not anywhere close to a definition of curb stoning. What he was doing was his friends had cars on his property, and his friends were selling their own cars on his property. And that is not illegal in the state of Tennessee.
Further on that subject, the statement that a review of the law finds no license is required if you are allowing another to sell vehicles on their own, if you allow another to sell their own vehicle on your property. I would like to see that statement taken out of the report, because it seems to authorize an activity. And I'm not sure we're here to authorize an activity. I think we're here to see if there's a violation
I
of
agree.
our rules.
But when I review the law, I have to put my findings of what the law reveals or does not reveal. And in this particular case, what this case was, he was being cited for an activity, of illegal activity, that after review is not couched in our law. And because of that, then I had to put in my further review that there is no law covering this activity.
I could recommend an amendment of the language that you can put in there that says that, because what the committee is going to do and what the commission will do is they will authorize a recommendation. Our legal report is the way that we speak to you to get there for an agreement on it. You could always place in there prior to that sentence, wherever the sentence is that legal counsel suggests that, or it's of the council's opinion that, and that way the commission doesn't have to indicate that the commission is of the opinion that. You could indicate that language.
Well, that would
And
work
that's
better.
fine. Because that is what I'm saying. This is from me, yes, I'm fine.
I understand. We're saying I'm a little concerned with saying it's almost as if we're authorizing an activity that could be a gray area down the road. So if we could do that,
I'll put that language in.
I'd like to suggest that.
Let me put that.
Mr. Chair, I'd like to suggest that.
I'll take it.
Okay, thank you.
If no other questions, then that would conclude the legal report to the committee. And I appreciate everyone's comment.
And then the final will be done in a regular session. Any more comments on the report? I mean, none. We declare the meeting closed at 10:18.
You want me to break before we start the regular scheduled meeting? Director Stribling was going to give us instructions, restroom instructions.
Men's room across the hall. Ladies' room on this side. Go across the hall and turn to your right.
Try to get going in about 10 minutes.
Good job, Chairman. We should have been here on this whole. Wasn't playing to be, but good you was for.
I wouldn't stop at a sausage and biscuit if I knew that you needed one.
Man, needed you desperately.
Thank heavens you had that whole.
I'm going back to the main. I'm gonna go back to the main library now. What is it? Oh, now we fix to go to here, right?
How are you doing? Good to see
He's gonna be the biotic man.
He looked good.
Some of it's 16 years old. Oh, I know.
Like man. He did shut up stuff.
I made it three.
I'm doing well.
Yeah, I've had bronchitis.
Yeah.
I'm a coughing machine.
First day back, all right? Starts tomorrow, right? No, sir, ours started today. Oh, it did? Ours actually started tomorrow. Yeah, I don't know why they had off yesterday.
Was that your hire?
I wish they had started Thursday, just give me a couple days to sort it out. Get their feedback. So I'm feeling it's gonna be a long, they're gonna know what that is. Oh, man, Shane got up at 6 a.m. Yeah.
How are you doing?
Right.
Doing good. Happy New Year to you too.
Hey, Ronnie. Good. How are you, brother? Hi, Joe.
I'm good.
Hey, man. How you doing?
Not coughing.
Wow.
I would absolutely still too. Thank you.
Yeah,
This is, oh, awesome. I'll definitely do that. Okay, you stop both of us. They say,
Oh, good morning. How are you
swear I was going earlier and I was like, you're hot for a water. How are you doing?
Good. How you doing? Good to see you, man. Been to come with you? No. How did it take you to get here? Oh. You just told me.
Oh, Howard. Hey, good to see you. That's good to see you.
Yeah.
Fellas, I'm gonna have to navigate these tight waters. Excuse me. You get it? Don't knock over the flag. We're all right. Now we've got, she's fine. She had a kind of hard year.
You're gonna finally face down.
A little bit of health issue, but it seems to be
Sit up.
if this thing.
Fold it up in a triangle. Like this.
I appreciate that.
Yeah.
At least somebody around here else sees that. That's important.
Depends on what. Getting off to a late start, it'll be tight.
We're lucky we got this.
No, I'm married. No, it's just chilling. It's keeping me warm. Yeah, I didn't bring mine today. I figured, well, I'm only walking 100 yards here.
You did?
I use it all with mine all
You
the
just
time.
gotta keep working with it, keep working.
Oh, I don't even travel with my laptop now. I just travel with my iPad.
Yeah, I've got MacBook Air. If that makes any sense. Where did you go? To iBooks? Oh, gosh, that's all legal review. Put on.
Right now. Last.
You keep hitting it after I hit it.
Got it in.
Are we waiting on anyone else? Has a name tag out? All right, okay. This is January the 7th at 10:25. We'll convene the quarterly meeting of the Tennessee Motor Vehicle Commission. Director Stribling, if you'll have a roll call, please, sir.
Billy Keck. Lynn Webb.
Here.
Clara Schaefer.
Here.
Don Parr.
Here.
Mark Purtle.
Here.
Reed Trickett.
Here.
John Murray.
Here.
Nate Jackson.
Here.
Donnie Hatcher. Ronnie Fox.
Here.
Kevin Cullum.
Here.
Joe Clayton.
Here.
Wade Hinton. George Bass.
Here.
Stan McNabb. Chairman Roberts.
Here.
Chairman, have a quorum.
Very good. Our sympathy goes out to McNabb family. Stan McNabb's mother-in-law passed away, thank you. And also understand Commissioner Keck is not feeling well now. I'm not certain how long and how that's coming, but keep all those folks in thoughts and prayers. One of the first orders of business that we need to do is to adopt Robert's Rules of Order for the next year. So if we could get a motion to adopt Robert's Rules of Order for our proceedings.
Commissioner Jackson, motion.
Motion.
Adopt the rules of order.
Mr. Bass, second.
Second by Commissioner Bass. All right. By voice vote, all those in favor say aye.
Aye.
Any opposition, say no. That passes. All right. If you please review the minutes from the last meeting. That's dated October the 8th, 2012. And we'll need to either approve those or revise those minutes, as you see fit.
Approval.
A motion to approve, is that Commissioner Clayton?
Yes.
Okay.
Second.
Second by Commissioner Fox. By voice vote, all those in favor of approving the minutes from October the 8th, 2012, say aye.
Aye.
Those opposed? Okay, you adopt the minutes from the last meeting. You should have a copy of the agenda for today's meeting in front of you. You'll need to adopt those minutes. I'm sorry, the agenda. We have a motion to adopt from Commissioner Jackson.
Second.
Second from Commissioner Pearl. All those in favor say aye.
Aye.
Opposition, say no. That passes. The meeting notice was posted on the motor vehicle website December 19th, 2012. That's notice of this meeting. Is that correct, Director Scrivener?
Correct, Chair.
All right. We'll go straight into appeals then. The first salesperson's license appeal is Jamie Matthew Duty, Slant Motors, Kingsport, Tennessee. Is Mr. Duty in the audience? Well, sir. If you want to come up to this round table right here. If you look on your iPads, go to the license appeals. You should see Mr. Duty's license application, and there's some other information. I'll ask the staff the circumstances of the rejection of the application.
Mr. Chairman, this, Mr. Duty was convicted of a felony. His end of sentence is February 11th, 2013, after 5 years that our statute calls for, 2/11/2018. And the felony conviction was for maintaining a place where controlled substances are used or sold.
And the 5 years is up when?
The sentence is up February 11th, 2013. 5 years adds 5, it's be 18.
Mr. Duty, would you like to speak to the commission about the circumstances and why you think?
The statute that I pulled up is you're denied for, if you have a felony of moral turpitude. Moral turpitude is defined as lying, cheating, or stealing. Fraud, bad checks, or fraud in the business or what have you. Of course, as he said, I had marijuana charges. That's what preceded my felony. So I feel as though that don't fall underneath this statute of moral turpitude. And I realize I made a mistake. Don't get me wrong. I ain't saying I didn't, but as far as the statute reads, it's moral turpitude, and I just feel like that's not what mine falls under.
So your reasoning is a legal reason,
Sir,
legal interpretation. Well,
I may have, but that's the statute that I have. I don't know, if it's changed or anything or what have you, but that's what it says, is moral turpitude. Being convicted of moral turpitude less than 5 years after you're off probation or what have you, and that's whenever it's, but mine's got nothing to do with moral turpitude, lying, cheating, stealing, like I said. It was marijuana charges, so I feel like I don't fall underneath that statute. This is my argument.
Mr. Duty, do you have any legal training?
No, sir.
Okay.
I just had it pulled up,
Certainly. Just wanted, since your appeal seems to be based on a legal interpretation, I just want to clear up the fact that that's what the website's for. So we understand. Members of the commission have a question, or would our legal like to? Since the legal issue has been brought up, let me go to our legal staff first.
Well, I'd give the commission members this, is that and this happens time to time, is that the definition of moral turpitude is difficult, inherently difficult. In fact, this is what the Tennessee Supreme Court has said about moral turpitude. This is the Tennessee Supreme Court's adopted definition. That is an act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow man or to society in general, contrary to the accepted rule or right and duty between man and man. It is an old definition, and the Tennessee Supreme Court has actually indicated that there is not a good general definition for it other than that. The courts have gone on to say that any offense that is what we in legally is called malum in se. Malum in se is basically where it involves, where there's a crime that involves an intent with moral turpitude, as opposed to just a prohibition, a law that's a prohibition against doing something. There's been some legal articles that have indicated that in this case, where his conviction is a crime that would be, I believe it was attempt for possession of marijuana for distribution and for maintaining a place where it was sold, that there are some legal articles that would indicate that the acts that he was conducting were acts that would attempt to corrupt people in society. and that those drug offenses are involve moral turpitude in that. So I would just give that to the commission to decide.
Mr. Duty, I have some concerns about the way you're going about your appeal, not whether you're correct or incorrect. My concern is you're basing your appeal on a legal interpretation, and you're not represented by an attorney. Now, you're not required to.
Okay.
But
I didn't know how others to go about it. I mean,
Well,
I'm not.
we don't expect you to be an
Right.
expert at this.
Right.
But there is, when we get into an appeal in a legal sense, you're not being an expert, and we're not all experts here. There are some attorneys on the commission, but we're not all experts in that as well. As to Mr. Landorf's point, moral turpitude can be loosely interpreted or very strictly interpreted, and it's been bounced around through the legal system for years. Depending on some of the activity, and I think the commission would like to hear more about the activity that you were engaged in. For instance, did you sell some of this stuff to minors? Which would be, in my view, not to prompt you, but there are circumstances that might move this into a different area. So a strict interpretation of moral turpitude, I don't think will serve you very well this time, especially not being represented by legal.
Right.
Now,
I got it.
with that said, we can proceed, or you can make a.
I can tell you anything you want to know.
Okay.
I mean, anything over a half ounce in Tennessee is a felony, and if it's in 2 different bags, it's considered for resale. And it was in a couple different bags, and that was what they got. Was it was pretty much like a sandwich bag full. But there was 2.
Now, were you selling?
No, sir. They didn't get me for selling anything. They just got it packaged for resale.
Let me ask you a different question. They didn't get you for selling.
No.
My question is, did you sell?
No. I was running, I had a shop, had my own business. You know, I smoked. I mean, and whenever I got caught in 2009, I quit. I ain't done it since. I ain't drank nothing since. It just wasn't worth it to me. You know what I'm saying? It's just not worth it. You know, since 2009, I haven't touched nothing or done anything, which I still was somebody that was, you know, I wasn't always somebody that paid my bills. I got to get ahead. I mean, I just smoked marijuana at the time, and,
Okay.
you know, I made a mistake.
Are there some questions from commission members?
Yes.
Commissioner Jackson.
Did you, I mean, you said you had it in 2 separate sandwich bags.
Mm-hmm.
I'm familiar with that. Were you buying it just for your own purpose?
I'd buy that much, and it was 2 different kinds. So I had it in 2 different separate bags. So it was 2 different kinds.
If you would, go into detail. How were you discovered? I mean, what triggered them finding you with the marijuana? Tell me a little bit about that.
Well, you're sure everybody's familiar with a confidential informant.
Okay.
Confidential informant said I had large quantities of marijuana stored in my house.
Okay.
And that's all he had to say. I mean, that's all he's got to say. And they can get a warrant and come in, and that's what the detective told me, that they was looking for large quantities of marijuana, and I just kind of laughed. It wasn't a funny situation, but I said, you're not going to find nothing like that here. But they found what they found, and that was enough to charge me, of course. You know.
And it was found in your home?
Yes, sir.
I don't know if the attorney, I see on here where it says marijuana for resale. Is that, can anyone help me? Is that normally what the law says, if they catch you with a half ounce or a little small amount?
If it's in 2 different bags. If it had been in 1 bag, they couldn't have got me for resale, but it was in 2 different bags is the reason that they got me for resale. I said, how can you get me for resale if I didn't sell it to nobody? Because I know for a fact you didn't catch me selling it to nobody. He said it's in separate bags. That's what the detective told me. I mean, the night I was in, got arrested and everything.
I would be hesitant that the and I don't know, but I'd be hesitant that the statute actually says if it's in 2 different bags, it's with some kind of intent. Generally, these things are about weight. Generally, in the circumstances that they have involved with it is how they actually make the charge. So the district attorney at the time, whoever did this, they thought that they had sufficient facts to show that it was with intent for resale, which allows it to be a felony, which when they get them under a felony, it makes them much more serious of a crime. But in this case, it was attempt.
Yeah.
Which-
Attempt to
right.
possess with intent.
It was an attempt to possess, which actually attempt goes less than the actual possession, but it gets so near to it that it's a serious offense.
So they had an informant notified the police that you had possession of marijuana in your home.
Pretty much.
They showed up with a search warrant. Were you there? Were you actually there when they showed up? Or
Oh, yeah.
you were there?
Yeah, they just told me I'm sure to come home. And that's all it takes is just a confidential informant to say somebody.
Mr. Duty, you said you had a shop before. What line of business were you in, and what have you done since 2009?
I would detail and mechanic, minor mechanic, but mostly detail and stuff like that. The guy that has a shop with me runs a generator business, so sometimes I help him with his generator business also. But I've only had I'm 37, I've had maybe 4 jobs my whole life. I worked in factories for several years, and I detailed at a car lot for about 4 years. I've not had many jobs. I stayed where I got employed for as long as felt like the job was there to improve. But I just ran that shop out and detailed. Had a pretty decent detail business and done that. But I'd minor mechanical stuff too. But this one is.
Mr. Duty, you currently are running a detail shop.
No, sir. No, that was.
What are you doing now?
That was
I might have
then.
missed that.
I was detail for Slant Motors at the moment, and just felt like salesman's what I'd like to step up to, and filled out for the license and didn't,
How long has Mr. Slimp been licensed? Do you know approximately?
18 years, I know.
Would you be there on those premises full-time if you had a license?
Yes, sir. Yes, sir. I wish I could have brought a slew of people. I wish everybody here knew me. You know what I mean? You can only go by what the paper says and what somebody speaks in 10 minutes, but I just really wish everybody knew me as a person. And Jim Slint was about for me, I'm sure.
Any further questions?
Is anyone here from the dealership?
Yes, sir. My manager's here and long-time friends here. Kevin Jackson.
Mr. Jackson, would you like to speak on behalf of Mr. Slim?
He's done a good job. I can't add anything. We don't have a problem with Mr. Duty working for us.
You have a salesperson's license.
Yes.
Any further questions?
Mr. Chairman?
Yes, sir.
Mr. Duke, you said there were 2 sandwich plastic bags, and about how much does a sandwich bag of marijuana weigh? I just don't have any
I
knowledge.
got caught with 74 grams, and that would be, there's 30 ounces,
About that.
30.
In 30 grams in an ounce.
Yeah, that's it. I had 2 of them in a sandwich bag. Well, two separate ones in a sandwich bag. So it would be equivalent to one whole sandwich bag full is what it would be equivalent to, just to.
So you had about 2 ounces?
Mm-hmm, like 2 ounces.
Oh, okay. Thank you.
That's what I had.
Any further questions?
Have you completed your parole, or is that next month?
37 days.
Okay.
Maybe I'll be off probation.
Okay.
And I could have brought something from my probation officer, but I mean, everything's good with her. I mean, I'm one of her easiest ones, you know what I mean? I learn pretty quick, you know what I'm saying? Things, as soon as everything happened, I done learned my lesson, but I went to court for 2 years and filed it, and, you know, done the best I could. Spent every ounce of money I had, but that's all right. I just want a chance to, you know, move on. I believe I can add to society and not take away, you know what I mean? I mean, I really do.
Commissioner Pearl.
Mr. Chairman, Mr. Duty, was there any other person charged in this crime other than you? Was there anybody that was considered to be involved in a conspiracy with you?
No. You mean what?
No, you were the only person involved in this crime?
Yep. Yep, I was the only one. There wasn't no bunch of ring of people or whatever. No, I was the only one.
Legal counsel, in light of the correspondence from Mr. Duty regarding his appeal, state's case law, is the chair in order to, based on the interpretation that counsel has given us of moral turpitude, is the chair in order to ask that any motions not include moral turpitude?
No, I don't believe so. There's not, you know, the Tennessee case law on what is and is not moral turpitude is changing, because they generally bring up specific crimes and specifically whether or not this is or is not moral turpitude. They don't list, you know, an entire list of it. I cannot find in Tennessee case law when I did my research that attempted possession of marijuana of a certain amount is not a crime involving moral turpitude. It's not in there. So I would say it's at the discretion of the commission to make an interpretation on the definition that I gave earlier. However, given that interpretation earlier, because it has to do with moral conviction and one duty that a man owes to man in society, men and men generally, it could be women, and what you owe into society, I would take it that the commission basically, you know, expound upon your own convictions of what a person owes to their society. I have found case law, not in Tennessee, but in California, that possession of narcotics with the attempt to distribute with intent to sell has been found to be a moral turpitude. But that is, of course, in California, not in Tennessee. So I don't see anything, I don't have anything in front of me where the Tennessee courts would have made a ruling that something like this is not moral turpitude or does not involve moral turpitude.
And for those reasons, I would, I won't, these are, doesn't sound like I can give the commission instructions, but I would say that my hope is that any decision that we may make to grant the appeal or not grant the appeal would not include an effort to interpret moral turpitude, for fear that we'll be in a rubber stamp position on these cases going forward.
And I think that really of the offense is basically with the intent to distribute, intent for resale. I think is more goes to that. What is moral turpitude? The fact that it was marijuana, I wouldn't want to say as, because as you all know, recently other states have found that possession of marijuana is not a crime. It's not a crime whatsoever within certain restrictions. So I'll just give that to you all.
Okay. All right, Commissioner Pearl.
Mr. Chairman, in light that there's at least 3 states that either have a moral or legal debate as to they're going to make state laws that make smoking marijuana legal or owning it for your own possession legal or illegal, and the fact that this gentleman has paid, in my opinion, a significant penalty of 2 years in state prison, whatever part of that he served, or in the workhouse. and that no other person was involved in this, and it was a small amount. It's my personal feeling, and I want to make a motion to approve this license because I think that we're hurting society if we don't give this gentleman a chance to be a productive citizen. And if anybody else were involved, I would not be making this motion. But in light of the circumstances, I would move that we approve his license.
On the floor, we have a motion to approve the license application for this gentleman.
I'll second it.
Aye.
Pardon me?
I'll second.
Second. Commissioner Fox seconds the motion. Is there discussion of the motion to approve? Hearing no discussion, I'll call for a roll call vote.
Commissioner Clayton?
Sustain.
Commissioner Clayton, what'd you say? Abstain.
Sustain.
Okay.
Sustain.
Commissioner Carr?
Yes.
Commissioner Purtle?
Yes.
Commissioner Cullum?
Yes.
Commissioner Murray?
Yes.
Commissioner Trickett?
Yes.
Commissioner Bass?
Stay.
Commissioner Schaefer?
Yes.
Commissioner Webb?
Yes.
Commissioner Jackson?
Yes.
Commissioner Fox?
Yes.
Chairman Roberts?
Yes.
You have 10 in the affirmative.
Mr. Duty, the staff will grant you a salesperson's license.
Thank you very much.
Congratulations.
Do well.
Very, very much.
Michael Paul Good.
Yes, sir.
Yes,
Thank you. Thanks, sir. Mr. Good.
Yes, sir.
Okay. Would you all like to have a seat? Would you prefer to stand?
Yes,
And you are, sir?
Kevin Ritchie, Jim Sales Manager, Dodge Nissan.
At where, sir?
Dodge Nissan,
Dodge Nissan. Where's the location?
Memphis, Tennessee.
All right. Could we hear from the staff as to the reason that this applicant was denied? Gentlemen, you're welcome to sit if you choose. We'll, as you see, it takes a few minutes. Just pull, there you go. Good idea.
Mr. Good has received a felony conviction for cocaine. The sentence was in February of '05 and had a length of 151 months. The end of sentence comes August of 2017. 2022 will be when the 5 years are
Yeah, and I received 2 sentence reductions, one for the cocaine law, and I took a 144-hour drug program to reduce my sentence by 18 months. So, and the sentence is February 22nd, 2013.
Do we have documentation to support that?
No, sir, I don't.
You're welcome to testify to that, but
That's all.
We can comply.
but that's part of our deliberation. Why don't you continue, Director Scribner?
The information we have been provided doesn't reflect that information. We'd be glad to take that into consideration if it's sent to us. But as it stands now, with the information that was provided us by this individual when he made his application, the end of sentence is August of 2017, and the extra 5 years as per the statute will be August of 2022.
Mr. Good, let me ask this question out. You're welcome to proceed without this supporting documentation for your statement. If you had rather come back with this documentation to the next hearing date, you can do that without any prejudice here, or you can proceed. That I wanted you to know of your options. Now, the next meeting would be in April.
Yes, sir, I will proceed with that.
Okay. All right. Okay, Mr. Good, we'd like to hear from you, sir, as to your reason that you feel like this should, that the staff denial should not be upheld.
Yes, sir. Everything that he said, that was my original sentence, and everything that he said was correct. I actually did 88 months. I was sentenced to 151, reduced to 121. I served 88 months for trafficking cocaine, which I am guilty of, which I have paid my debt to society. And while doing that, I used that time to try to better myself. As I stated towards the end of that sentence, I took a 144-hour drug program, which I'm still involved in. Right now, I still am part of an outpatient program with that, which I'm go to counseling, which I'm still working on bettering myself. Right now, I came to Tennessee. I'm originally from Arkansas. I moved to Tennessee to start over. And my concern is now is the example that I set for my two children, because I know in the past I've set bad examples. And while I feel like I've paid my debt to society, now I want to pay my debt to my family, and I want to show better examples and better role models. And that's why I came here. I came to Tennessee for a start off. Like I said, I am from Arkansas. When I got out, I came to Tennessee to be with my family, and that's where my focus is. You know, I feel like I paid my debt to society, but I still have a debt to my family, and I'm trying to rebuild those relationships, which is what I've worked on while incarcerated and getting out. I live with one of my daughters right now, and I worry about examples I've set for them, and I'm trying to redo those mistakes.
Are there questions for this applicant from members of the commission?
Commissioner Jackson.
I'll get to you.
Sorry. Let me make sure I got it. Was the date of the incident we're talking about was in 2005?
2000. I was convicted in 2004. I was sentenced April 25th, 2005 is when I started serving my sentence. I was arrested October 3rd of 03. Reported to federal prison April 25th, 2005. And I was released August 2012.
Tell me a little bit about trafficking of cocaine.
I was convicted of selling cocaine as the last gentleman. I mean, it was from an informant. Yes, I am guilty of. I served my 88 months for this crime. But can I tell you, everything that I was guilty. I did commit this crime. And I have worked on bettering myself, and I have worked to repay my debt for what I've done, for what I did was wrong.
So this, the crime took place in 2003.
Yes, sir.
I assume you, before you went to, you ended up going to jail, I assume that the court system took it so long from 2003 to finally you went in 2005.
Yes, sir, that is correct. That's correct.
And then you were released on 2012.
I was 29 in 2012.
I noticed a charitable organization in here. Let's see that is. Dressing Charitable Inc.
Pearson Charities. This is the halfway house which I was released to.
Okay.
They sent a letter of recommendation to Assistant Director, Mr. Powell, supporting me in what I've done since I've got out, since I have been in their custody. And he supports me, and he just sent a letter with, with some kind words, because he had been around me.
Okay.
As a character reference, kind of.
How long did you stay there before they released you? How long were you in this?
I've been there since August 29th.
Of last year?
2012, yes, sir.
Okay. I noticed that I maintained employment while residing at the Okay. Where were you working at prior to applying for a job at Nissan? Were you working anywhere since that time, or this the only job that you applied for since?
This is my job since I got out.
Since you got out? Okay. Have you ever sold cars before?
No, sir.
This is to the general manager. What is he presently doing?
Presently, he's not working because as soon as we received a letter stating his sales license was denied, we immediately took him off. He still has employment with me, and that's why I'm here to speak, to talk a little bit about him.
You want to make your comment now, sir?
Yes, sir. Mr. Good obviously has done a substantial amount of time based upon his crime. Let me tell you about our dealership. I have very strict standards when I hire. I normally don't hire people in the car business because I like to get my people in and train them to do things the right way. If I did not see something very good in Mr. Good, he would not work here, and I definitely would not be here spending my day in Nashville and trying to get him a job. He's shown numerous times, he's shown outstanding service to customers. He's definitely a great employee. He goes above and beyond what his role as a salesperson is, taking care of customers and service. You can go online and see a lot of customer reviews about him. They go online and leave comments at Dealer Rater and stuff like that. You'll see his name about how well of a job he did on deliveries. He went and got a customer's car, brought it back for oil change. Just a lot of different things that you normally wouldn't see. He's gone above and beyond, so he definitely has the capability to be very successful. We supply all the training that he needs. He hasn't sold cars before, and that's a good thing. You know, we give a lot of training. Every day we do training. He has the ability to achieve. He's going to do great in this business. You know, he has a family to take care of. He's got a couple of children. He just wants to do right, do good by them. He's definitely made a turnaround in his life. He's made a commitment to do good things. So I think it's in the best interest for you guys to allow him to have his license so he can, you know, continue with the path that he's chosen and, you know, be successful and be a good citizen. So that's why I'm here supporting him. And AutoNation has backed him 100%. We've all backed him at the dealership, and we just want to see him get an opportunity to prove himself. I am very strict on work. He's on time every day. If an employee is out of line whatsoever, they are reprimanded immediately by me. He's always been on time, first one there, last one to leave. I mean, he shows a lot more than other people, so he just needs an opportunity.
Did he just show up to your dealership seeking employment, or how did?
He did. He stopped by. We have a brand new dealership. He drove by, I think, and just wanted to come inside and talk to him. And after speaking with him for about an hour, we've also put people through a little test. It's a couple different kind of battery tests we do, and people scored very well. He has a lot of personality benefits. That he communicates well with others. Just a lot of good things about him. You really can't see in here, but he's going to be good.
Did he share with you his back?
He did. Yeah. You know, I believe everybody deserves, 99% of everybody deserves a second chance. You know, we all make mistakes in our life, whether or not we're caught or not. We've all done it. You know, it's how we handle the mistakes we made and what we learn from them is what we should be judged by, not from the mistakes we made.
So if he shared his background with you as to, you know, what he had done in society, did you personally say to him, go ahead on and apply for your license, knowing that, you know, he had a conviction felony? Or how did that?
That is my fault 100%. I'm not from Tennessee. I've been here about 5 years, but I don't understand exactly how that works. I thought you could hire somebody and apply for a license, and they work, and if it gets denied, you take them off the floor. If they approve it, that's not what we do, and I apologize. I'm saying it's not. I've run into this one other time, and I thought it was okay to do it this way. You know, but if he didn't show himself for the couple months he worked for me, then I wouldn't even be here. So it'd be a weak point. But I do apologize. I'm researching this better so I understand it better if this situation arises again.
So he started selling before he made the application for his license?
No, you fill out an application as soon as you start. We send it in, and you wait. I mean, that's. I thought that was a normal procedure.
I can clarify, is that the rules state that if somebody has an application for a salesperson pending, that they can work as a salesperson so long as they are supervised. Now, if that comes back denied, then they're no longer.
The day it came back tonight, he was off the floor. It was 3 o'clock in the afternoon and on a Friday, and I took him off. That was when we got the letter. He was trying to help him. He was off again one weekend. Is that okay?
Yes.
Okay.
Commissioner Bass, are you still under supervised release?
Yes, sir.
For how long?
I will be in the halfway house, the distance areas which you spoke of, until February the 22nd. And then I will be on federal probation for a term of 10 years.
Now, who do you report to?
I have not met my probation officer yet.
Now, you moved from where?
From Searcy, Arkansas.
And you did get permission to move from Arkansas?
Yes, sir. Yes, sir. You have to have permission before they will release you to another state to move. So towards the end of my halfway house tenure, then I will meet my probation officer. They just haven't come to meet me yet. I have been assigned one, but they haven't come down to meet me yet. But before February the 22nd, I will meet. And after February the 22nd, I'll have 3 days to go and meet with them personally.
Is this for a minimum of 10 years?
Yes, sir.
Mr. Chairman? Mr. Good, how much, what was the quantity?
It was 63 grams.
63 grams. 4 pounds?
No, that's 2 ounces.
2 ounces? Oh, you said grams, I apologize. 2 ounces, thank you.
A comment, Mr. Good, Mr. Ritchie?
Yes, sir.
The opportunities to traffic in drugs in the automobile business is right out there. It's a fairly easy place. I say not easy. Easy is the wrong word, but it's the opportunities are there to traffic drugs in automobile. But you're handling large sums of money. You're in different automobiles. There's all kind of logistics that favor selling drugs in the automobile business. You've thought about that, I hope.
Yes, I touch every customer that comes in my door. I touch. I'm aware of everything. It might sound crazy, but I work 3 times more than anybody you know, I'm sure. Every customer comes in, I touch. Every deal, everything that goes on, I know. And the last thing that would ever go on at my dealership is anything illegal. I can guarantee you that. I've worked too hard and gotten too far to let something like that happen. I mean, it just doesn't happen. I know when somebody's 2 minutes late.
Mr. Good.
May I speak on just some of the things that I lost when I went to prison, and how it affected my family, which I didn't realize when I was committing the crimes that I committed, was what it did to my mother, my father, my children. While incarcerated, my mother passed away, and she raised me by herself. And I was not allowed to go see her while she suffered from cancer. I was not allowed to go to her funeral. And these are things that I will never forget. I will never forget her face at my court date. I will never forget my children's face. They seen me visit and cried. I will never forget not being able to go see my mother as she passed away and needed me the most. And these are things that I learned from the decisions that I made, that they don't just affect me, that they affected a lot more people. And that's why when I went to prison, I committed to changing my life. That's why I took this residential drug abuse program, because I needed the help. That's why I go to counseling, because after doing that amount of time, I need a support system, and I have a very good support system. I have my family in Memphis, Tennessee. I have Pearson Charity supporting me. I have this man here come down here. He is supporting me. I have a wonderful support system.
Further questions? Hearing none, the chair would entertain a motion.
Commissioner Jackson, I entertain a motion that we grant him his license.
motion, Commissioner Jackson to grant license to this applicant.
Second.
Second by Commissioner Webb. Discussion. Hearing none, Chair calls for a roll call vote.
Commissioner Fox,
Yes.
Commissioner Jackson,
Yes.
Commissioner Webb,
Yes.
Commissioner Schaefer,
Yes.
Commissioner Bass,
Abstain.
Commissioner Trickett,
Yes.
Commissioner Murray,
Yes.
Commissioner Cullum,
Abstain.
Commissioner Purtle,
Yes.
Commissioner Parr,
Yes.
Commissioner Clayton,
Yes.
Commissioner Roberts.
No.
Mr. Chairman, you have 9 yes, 2 abstain, and 1 no.
Mr. Good, you'll be granted a salesperson's license. Good luck with your career. Thank you, Mr. Ritchie. Okay. William B. Massengale. Is Mr. Massengale in? Okay, since we've had an action by the staff to deny the application, Mr. Massengale will need a motion for action from the commission.
I make a motion we
Jackson,
appeal.
with the staff recommendation.
Second.
Motion Commissioner Jackson and second by Commissioner Cullum to uphold the denial. Now, a yes means it's denied in this case. That's what I'm interpreting the motion. Okay. All right, roll call vote.
Commissioner Clayton,
Yes.
Commissioner Parr,
Yes.
Commissioner Purtle,
Yes.
Commissioner Cullum,
Yes.
Commissioner Murray,
Yes.
Commissioner Hatcher, Commissioner Trickett,
Yes.
Commissioner Bass,
Yes.
Commissioner Schaefer,
Yes.
Commissioner Webb,
Yes.
Commissioner Jackson,
Yes.
Commissioner Fox,
Yes.
Chairman Roberts.
Yes.
Mr. Chairman, you have all yes.
All right. Casey Dale Robinson.
Mr. Chairman, can I make a comment before he speaks?
Yes, sir.
Mr. Robinson, as the commission can see, is applying for a job for me with us. And I would, of course, I'll abstain from voting, but I would like to make some comments on his behalf if I could after he speaks.
Would you like to?
If you'd like me to.
I don't think it matters.
Okay.
All right. The reason for denial, staff, please.
Mr. Robinson was received and felony charge on aggravated burglary. Date of sentence was September of 2012 for 3 years, all on probation. Probation ends 9/10 of 2015. That'd be the end of sentence, the end of probation. 5 years on that is 9/10/2020.
Mr. Robinson, would you like to address the commission as to some of your circumstances and what you're basing your appeal on?
Yeah, absolutely. I'll tell you a little about me first. Raised in a two-family home, very loving home, Christian home. Grew up knowing right from wrong. Played sports my whole life. Went on to college on baseball scholarship. Sustained an injury to my elbow while in college, and was in a extensive long-term rehab for my elbow and was prescribed painkillers at that time for an extended period of time. Became addicted to those prescription pills. Ended up leaving that school and moving home. That drug use escalated, and over the past, I guess roughly 10 years, off and on, been addicted or had clean time, of a year, somewhere around there. But it was because I was trying to clean up my life for everybody else, for my mom and my dad, for girlfriend, what have you. It was everybody other than myself. When I got into trouble, I was running my family's landscape business at the time, and took a I say friend, I'll use that term very loosely, with me to work. Came around the side of the house and he was kicking the back door in. And so, because I was there while he committed that crime, I was also part of that. So charged with him in that. Spent 33 days, in jail, and decided that I had to make some changes in my life. I went to a long-term 12 to 18 month treatment program called Teen Challenge. I don't know if any of y'all are familiar with that. It's a long-term residential Christian discipleship program, to help people struggling with life-growing addictions and issues. Helps them overcome those through, the power of Jesus Christ and through biblical principles. And since going there, I've given my life to God. I let Him lead it now. He's given me back everything that I took away from myself through my selfish actions. And now I actually own my own ministry now that I do on the side. And like these last two gentlemen that set up here, I'm asking for an opportunity to continue being a successful member of society, and just asking for an opportunity to continue to better myself. And the Fox family, I've known them, my entire life. They've offered me a wonderful opportunity, and I would like to take that granted that this bill passed.
Thank you. Any questions for Mr. Robinson from the commission? Would Mr. Fox like to address the commission?
In my 35 years in the car business, I've never come before this board to ask for a salesman's license approval. But Casey was an exception because I've known his grandparents all my life. And I went to school with his mother, so we went to school all through high school together. And his grandmother came to me back last fall and asked if I could put Casey to work. Casey would like to sell cars. And I told her what it involved. I'd have to go before this commission to get his license, but that I would try. And Casey, I've known him all through school. I say he was an outstanding athlete in high school. He went to college on baseball scholarship, and he made the wrong decision. Come back, work for his dad's landscaping business, and just got in trouble there. But I know for a fact that he's turned his life around, and he'll be working with me on the showroom floor every day, and I'll see him. And if he messes up, I'll be the first one to send his license back. But I think we can make a difference in this man's life and give him a job in the car business. And I'd appreciate it if you'd help him.
Thank you. Any questions for Mr. Fox?
I got one for you. Just one, you said your friend kicked the door in. Can you just tell me a little bit about that? How did?
Well, I came around the side of the house. This was a client that we had we've been working for over 10 years.
Okay.
So very well-known client to us, very well-respected client. She's a vice president with TVA. So I guess this fellow knew that she would have a lot of possessions in the house. He was on drugs as well, going through withdrawals and what have you, and he didn't tell me anything about it. I just came around the side of the house. He was kicking the door in, and I didn't have time to say, don't do that. He was already in the house and gone. He got picked up on some other charges a couple weeks later, and started singing like a canary, pretty much. And they came and picked me up a couple weeks after that and charged me with that same crime. And that's when I spent the time incarcerated. Went straight from being incarcerated to that long-term treatment facility where I spent 16 months.
Any further questions?
Did you go in the house?
No, sir, I did not.
Did he give you anything out of the house?
No, sir.
So you weren't in possession of anything in the house? You just wrong place, wrong time, standing there?
Yes, sir.
Sir, what type of sentence did the
Well, I was.
the gentleman that
He is serving 3 years in state penitentiary right now.
Thank you.
Mr. Chairman, I'd like to make a motion to approve the license.
Mr. Webb makes a motion to approve his license application.
Second.
Second by Commissioner Purtle. Any discussion of the motion? Hearing no discussion, I'll call for a roll call vote.
A yes vote will be to approve license. Commissioner Trickett,
Yes.
Commissioner Bass,
Yes.
Commissioner Shaper,
Yes.
Commissioner Webb,
Yes.
Commissioner Jackson,
Yes.
Commissioner Fox,
Abstain.
Commissioner Murray,
Yes.
Commissioner Cullum,
Yes.
Commissioner Purtle,
Yes.
Commissioner Parr,
Yes.
Commissioner Clayton,
Yes.
Commissioner Roberts.
Yes.
Got a majority.
Mr. Robinson, you'll be granted a salesperson's license. Good luck with your career, sir.
Thank you very much.
Jason A. Larkin, Town and Country Ford. Jason A. Larkin, Town and Country Ford. We don't have the applicant here. The staff has recommended denial. Is there a motion to uphold the denial?
Commissioner Jackson, support the staff decision.
Right. Commissioner Jackson makes a motion to uphold the denial by the staff, and Commissioner Shaper seconds. Any discussion? Hearing none, Chair calls for a roll call vote.
The yes vote is to uphold Commissioner Clayton,
Yes.
Commissioner Parr,
Yes.
Commissioner Purtle,
Yes.
Commissioner Cullum,
Yes.
Commissioner Murray,
Yes.
Commissioner Trickett,
Yes.
Commissioner Bass,
Yes.
Commissioner Shaper,
Yes.
Commissioner Webb,
Yes.
Commissioner Jackson,
Yes.
Commissioner Fox,
Yes.
Commissioner Roberts.
Yes.
Majority.
Troy Dale Moulton. Troy Dale Moulton. Apparently, Mr. Moulton is not in attendance. Is there a motion to uphold the denial or to not uphold the denial by the staff?
Commissioner Jackson, support the staff recommendation.
Second.
All right, motion by Commissioner Jackson to uphold the denial, and seconded by Commissioner Purtle. Any discussion? Hearing no discussion, Chair calls for a roll call vote.
Commissioner Fox,
Yes.
Commissioner Jackson,
Yes.
Commissioner Webb,
Yes.
Commissioner Shaper,
Yes.
Commissioner Bass,
Yes.
Commissioner Trickett,
Yes.
Commissioner Murray,
Yes.
Commissioner Cullum,
Yes.
Commissioner Purtle,
Yes.
Commissioner Parr,
Yes.
Commissioner Clayton,
Yes.
Chairman Roberts.
Yes.
You have a quorum.
All right. Christopher L. Whitney. Alto Village LLC.
Yes, sir.
Could the staff give us a review of the reason for the denial? Yes.
I didn't get Moulton who made the motion.
Commissioner Jackson, it was seconded by Commissioner Purtle.
Okay, thank you.
You're welcome.
Mr. Chairman,
Yes, sir.
the cover sheet for Mr. Whitney says Christopher E. Whitney, and I believe is Christopher L. Whitney, just for the record.
Okay. We would assume that's one of the same applicants, so
Yes, that's correct.
we'll correct it in our next minutes, if you would. All right, thank you, Mr. Purtle. And Mr. Whitney, would you like to give the staff, give the commission your reasons for, did we skip over the staff? Okay, all right, one moment, Mr. Whitney. Let me hear from the staff.
Mr. Whitney had received a felony for identity theft and making a false report. Sentencing date was October of 2010, which was for 2 years probation. The end of sentence is 9/13/14, and 5 years is 9/13/19.
Mr. Whitney, where is Alto Village located?
At Lebanon, Tennessee.
Lebanon?
Yes, sir.
Okay. Would you like to address the commission as to why you hope to get the denial overturned?
This all stems from a very
very long, lengthy, bitter divorce back in 2008, started in 2008. And ended up in a huge custody hearing. Never in my life that when I agreed to plead to this charge that I ever thought this would be the deal, because I was looking what had taken so long was the statute was so broad and overreaching in the charges, and what had happened was there was no clear definition. Basically what had happened is my wife at the time had joined a private service to go overseas in Kuwait. And during the divorce, that she put in motion to transfer to take my son over to overseas to Kuwait. And during the custody fight, she had moved around quite a few times, and I was trying to get my son. So we had gone into court pretty lengthy, and there was a couple of times that she didn't show up. Of course, you know, they upheld the ruling, and the judge and I didn't see too on the same level, so to speak. And basically, when she was granted the opportunity to take my son overseas, I said, you know, what am I going to do? You know, this is my son. And he basically told me to have my passport ready. So we went around and around for another 9 months. And as you know, during a divorce, you cannot change any of your life insurance policies, the automobile policies, titles, the phone records of utility bills, or anything like that. So she had a cell phone that was still in my name that she was using that I was paying for as part of the divorce agreement stuff. Well, there was a phone call made by myself that made to a best friend, one of my friends, that unbeknownst to him was me, that showed up as her phone number. So I was trying to try something out. Well, I hung up the phone. Next morning, you know, talking to my friend, he goes down to the police department, files a phone harassment charge on it because he evidently had some issues with it too. And they arrested him. Well, I kind of left well enough alone. Well, I got to doing some reading during, kind of hoping it would go away, just kind of left it. Well, during the course of that to the next court hearing, I was doing some reading and found out that she got her security clearance revoked for being arrested, that she could not be granted an overseas pass for this company. So that's the only alternative I had to keep my son here, so I did it. Kept him here. And we fought for another couple of years, but the detectives came in and said, hey, did you do this? And I said, yeah, I did it. You know, because by the legal definition, there's no law against it. There was nothing about it. But, you know, I looked at the detective and I said, let me ask you something. You have children? He said, yeah. I said, if your son or is your wife took your son and daughter and was going to take them out of the country, said you're not going to see him again, no ifs and buts about it, what would you do? You know, it's a hard thing to look at. Granted, what I did, I'm not proud of. You know, I hang my head every time I see it, let alone be put on national TV over it. It was bad. You know, to know when my son's going to see this later on, it's over. But the bottom line is I'm there for my son. I'm his father. So, long story short, you know, she was pitching a fit about what I did, which I did, but there was no statute. The district attorney was like this, and they were going back and forth. And finally, they came out with this agreement of identity theft, and the district attorney said, look, if you agree to this, you won't do any jail time, this is what it should be, in the whole 9 yards. And I looked at my attorney and said, Chris, you don't own any guns, you're not going to be able to own a gun, you're not going to be able to do this, but never did I ever think that it was going to affect me in the car business. I've been in the car business all my life, and I've never, ever thought this was going to affect me. So I agreed to it, just to keep from going to jail. Well, here I am today. A good friend of mine owns Auto Village. He and I have worked together for many, many years. I've done a lot of wholesale, and that's what the extent of this is going to be about. He runs his car lot. He doesn't have a whole lot of time to be pulled away. I do a lot of buying, wholesaling, not only in the car business, but not only in the sales end of it, but as far as automotive wholesale parts of the EMS industry. So, you know, here I am, and that's the bottom line. As far as any financial gain from it, there's no financial gain from it at all, none whatsoever. Did I make anything off of it? None. Matter of fact, it cost me, because soon after I pleaded this, I got a civil suit from her and her attorney, and paid dearly, dearly for that. So, once again, you know, the charge of what it reads on face value is, unfortunately, it should be a little bit misleading in this case, but it is what it is.
Thank you, sir. Are there any questions for Mr. Whitney from the commission members?
Commissioner Jackson, just help me with you make sure I understand the phone call that you used a cell phone that actually belonged to you, but it also belonged to her.
It was assigned to her.
Signed to her.
Yes.
So when we made the,
When you get your bill and you have multiple control lines, do you ever look at your bill and see, okay, do you have a son or daughter or wife and they're on the same plan?
Yeah.
You say like, this is your wife, it says your wife's name, Miss Jackson on there.
Right.
This is her usage, and then you got your son, hers. Well, the thing about it is, the bill was in my name.
Okay.
But because it had her name and that number, that was identifying her and her number, so that's where the legality was.
So who's the friend you was calling with her number?
It was a very good, close friend of mine.
Okay.
And he did not know.
Now, what was the purpose of that? I didn't quite understand it.
I just wanted to see if it worked. It's called tunnel spoofing. I just wanted to see if it
I
worked.
got you.
Mhm. A lot of bill collectors, buy here, pay here, use those to where they get a reference sheet and people call and they won't answer the phone because they know you're calling from the car lot, so they'll take the reference sheet and make it look like it's the reference of a person so they answer the phone. And that's exactly what, I just wanted to see if it worked. And it was fairly new technology at the time. It's very common practice nowadays. But once again, it's a borderline. It can be abused. And I did abuse it to the advantage of getting her security clearance revoked.
Mr. Chairman. Mr. Murray.
On your application, when it asked you, have you ever been convicted of a felony? And
That
you
was my
put no.
oversight. That was completely my oversight. I was looking at it. It was just my mistake. That's just the bottom line.
Is this, you fill this out by hand yourself?
Yes, sir, I did.
Who's the owner of this establishment?
Mr. Joe Lee.
Okay. You're welcome to come forward. And your name again, sir?
Joe Ali.
Joe Ali. Mr. Ali, you have an opportunity to make a comment to the commission if you choose.
Chris has been a friend of mine for a long time, and also he's a great help for our company because it's a small company and I do run pretty much all the aspects of the company, and I really like to have some help with buying a car for our company because every time I'm away from small dealership like ours, you know, it's really I'm also a hands-on kind of guy. Every time I'm away from the dealership, you know, really, I feel like, you know, I might be losing customers. By having Chris as buying a car for us, I can stay in my location. We have one salesman and myself and an ops manager. So really, we are a small dealership. So by him going out and buying a car for us, can keep me put to oversee the operation of our vehicle.
Did you not offer to assist him in filling out his license application?
I'm sorry?
You did not offer to assist
No, we
Mr.
don't. I
Whitney?
mean, it's his position. You know, we give the license to them to fill it out.
Any questions? Commissioner Bass?
Yes, I have a question about, have you ever been convicted of a felony? And you answered no. Did you ponder this before you put this down, or were you uncertain?
I was uncertain because there was actually a whole grocery list of charges at first when I was presented, and a lot of it was just misdemeanor charges. And because of the nature and the publicity of what had happened, it got rolled. I was under the impression at one time that it would be reduced at a later date when the publicity would die down. And I thought that would happen by now, and it has not. And my attorneys are right now working on it with the district attorneys and the civil attorneys to make that happen. But until that happens, here I am.
Or did you feel this would be oversight of the director?
I would think I would say it was my mistake that I didn't do my due diligence to look into it and contact my attorney and ask him for clarification.
Now, all this action was precipitated by your wife going to Kuwait and taking the children. Am I clear on that?
My son, yes, sir.
Your son.
I mean, the bottom line is you know, it was moved out of desperation. I mean, when you have an ex-wife that's pretty bitter and says, you know, I'm just gonna leave and I'm just gonna take it
Bitter,
with me.
bitter at you?
It was a bitter divorce. It was.
I just
it
mean
was a lot of
bitter at you?
Yes.
Not bitter against the automobile industry?
Well, she was a little bitter at because I was never home.
I'm sorry?
See, I was never home. You know, I can't imagine you guys can relate to that, but I was just never home because I was either at work or doing something. I mean, I don't know Mr. Struven personally, but I ran the dealership next to his dealership for years of fixed operations, and that's all I did. But it took a lot of work. It takes a lot of time, and But unfortunately, there was a lot more involved. There's a lot of. She had inherited a large sum, which I didn't want anything of. Didn't want any part of it. It's just the bottom line was.
Now, her inheritance, if this inheritance is a factor in her location, that's not an inheritance in the U.S., it's an inheritance.
It was inherited in the U.S., but one of the other reasons for her to move was the capital gains tax.
Now, she went there for employment, did you say?
She was going there for employment.
Who is she going to work for?
She was going for a Life Flight, a private ambulance company that will transport patients. It's a private contracted security service.
Is she from Tennessee?
No, sir. This happened about the same time, I don't know if you recall, years ago when a guy got arrested in Japan trying to get his son back. The guy went over there, he was married to a Japanese woman. She left the country with his 2 children. He went over there to get his children back because he got awarded custody. Guess what?
He was arrested.
He was arrested and detained for almost a year. So during that same time he was arrested was my case law. And about the same time my attorney out of Smithville, Mr. Vester Parsley, had a client that his wife went to Guatemala with his child. So here I am hearing 2 back-to-back stories. And I don't know, I'm quite sure every one of you guys know about dealing with attorneys, but their billable hours can add up pretty quick. It was a very costly divorce and a costly mistake. But the bottom line is, I was going to be his father. I didn't care.
This question is, I think, relevant to why you would need to take such drastic action. And my question is this, is your wife a U.S. citizen?
She is now, yes, sir.
She's an Italian citizen, but went to Kuwait?
Excuse me?
You say she's...
She's a U.S. citizen, yes, sir.
Catch me back up. Yeah. Your wife is an Italian citizen?
No, she is a U.S. citizen.
She's a U.S. citizen, okay.
I'm sorry.
I wasn't asking the heritage, I was just trying to establish why she left the country. Okay.
Mr. Chairman, had your wife been awarded sole custody and been given permission by the court to take your son out of the country permanently to reside?
Yes.
She had been given permission by the court?
At that point. Until we had to file a complaint with BOPAR to have some things looked at with the decision, and based off an appeal, there was some changes made in the custody hearing. Had I not done that, she would have went. There was nothing. There was no recourse. But because of that, I bought some time.
What is BOPAR?
Board of Professional Responsibilities. Those are people that look over judges, and I can't legally go into all
That's
the detail.
fine.
But if you could read between the smoke and mirrors of that, you'll understand what I'm saying.
Before she became a U.S. citizen, where was she a citizen of?
No, she's always been a U.S. citizen.
Oh, okay.
But she holds a dual citizenship, though.
What other country?
Here. I think France.
What's the status right now of your wife and child?
They're here now. I have what they call parental custodial care. We split the time. There's been a lot of headways between that time and now, but it was very costly.
And you said it made national news of some kind.
Yeah, it was Inside Edition on Dateline. Yeah, it's nothing like walking out your front door and seeing a bunch of new fans in your front house.
Staff, how much background is collected in a case like this. The only background we get for appeal is what we hear here. And there's some very complicated facts here.
Well, if I may, I mean, Mr. Chairman, the statute says that the commission has the discretion to deny any license where the person has been convicted of a crime involving moral turpitude. Basically, all you need is that conviction sheet in front of you and make a determination whether or not it's moral turpitude. If it's not moral turpitude, then you don't have the discretion to deny it. You should approve it. But if it involves moral turpitude, you have the discretion to deny. So all of the factors and circumstances involved basically don't play much for a legal argument. However, because it's discretionary to you, even though it involves moral turpitude, it's discretionary to you. The mitigating factors that he would present are these factors that he's giving now. But the commission doesn't receive anything such as, the transcript of the hearing or anything like that. We would have to pay to get things like that, Mr. Chairman, and those we don't have. But I'm sure this was probably a large file that would have been a large file.
Well, this appeal seems to be based mostly on motive, explanation of motive, and it's just not part of the record.
Well, it's the main reason why, I want to work. I've always been in the car business, and I want to branch out some of the aspects of what I do. And I enjoy the car business. I've never had any problems with the law. Never had any problems with anything at all except for this. What I'm asking here is an opportunity to continue to do what I like and do what I love, is continue to stay in the car business. And that's what I want to do. But unfortunately, because of this and the way it reads, and just like the gentleman said, it's at your discretion. I come before you and to plead with you and ask you to give me this opportunity to continue to do what I do and continue to make a living at what I love to do. But unfortunately, had I known back then that this was going to be an issue, I would have continued to fight because it involved my livelihood. This is all I know what to do. This is all I've done in all my life, and I've been so much successful at it, and I want to continue at it. So when I come before you and I ask you to please give me that opportunity, that's exactly what I'm asking you. Give me that opportunity to continue to do what I love to do. I wouldn't come here if I didn't think it was a serious. Matter of fact, I talked to the young lady on the phone several times. She said, "Look, please, please, please get me here, because I just want to get in front."
Chairman Roberts, Mr. Whitney,
Yes, sir.
the only thing you did through some type of new technology is that you went on to this program and made your wife's phone number appear on a call you made to another person.
Absolutely, yes, sir. And she got arrested because of that.
I move to approve the license.
Excuse me.
I make a motion to approve the license.
We have a motion to approve the license.
Commissioner Jackson, second.
Commissioner Jackson, second. Discussion. Do we have, I suppose we could do this, and I don't know if it'd be in our budget or not, but can we do a background check?
We, Commissioner, Chairman Roberts, when the application comes, we're provided a final judgment decree that includes what the sentence is about and the length and all that. We also run a state felony register. Sometimes if a person does not submit the final judgment decree, when we're running a felony register on every person, we can catch that indiscretion and ask for it. But everybody that submits an application that indicates a felony, they have to submit the final judgment to us, or while running the state felony register, if we find someone that indicates as a felon, we write a letter back to the dealership requesting that final judgment be sent before a decision is made. So that's done on every applicant.
Let's see, who made the motion? Commissioner Pearl. made the motion.
Second.
Since a vote has not been called for, an amendment or change in the motion can be made. I'd like to request stipulation of a background check for this applicant.
I'm in my motion, so.
Commissioner Jackson seconded it.
Yes. I'm just curious.
Well,
No, I'm sorry, sir, we're in discussion.
I think I have to rely on the staff attorney. We do have the other general counsel here for the commission. I mean, someone,
That's what this is, the background check.
yeah, that's what I was gonna say. I thought I saw background check in here. I mean, let me ask the commissioner, staff this. If you check everybody that comes in and you decide you're gonna do a registered, what you call a registered felony request or whatever you call it, if there's anything out there on that individual, it should show up. Am I correct?
you're correct.
Like, did we do that in this case?
Yes.
Correct. It's attached to.
It's in there.
Is that a similar background check to what
Yeah.
we're accustomed to
That's a
in
Tennessee felony
in
offender.
the hiring world?
Right, that's provided by the state. Any felon, this is a state register.
This is a straight registration that shows any felony in the state of Tennessee. If you paid for a background check, that generally would show any conviction, whether it's a felony or misdemeanor in all of the 50 states, whether it's a state or federal court. It's larger, more expansive than this. What the commission does is we utilize the Tennessee website for felony offender lookups in Tennessee.
I realize what Commissioner Jackson is saying. I appreciate that. We don't necessarily, by this amendment that I requested for a motion, want to begin that to be a required part of the process for an application. My reason for asking is due to the nature of this conviction, which was identity theft. And we've heard a lot of testimony by the applicant as to why, which are complex, and there are movements around that this applicant disobeyed the court. My understanding is that, from Mr. Pearl's question, that the court ordered possession, custody of the child to the wife.
Yes, and could I expand maybe a little
Please.
bit? And tell me if I'm wrong, but my understanding is that the court awarded your wife custody of the child to be able to take overseas to Kuwait with her. And because she was arrested, she was worked for a security company. Because she was arrested, her security clearance, which I have a security clearance, her security clearance was revoked, which means she couldn't go overseas and do that job. Is that correct?
That's correct.
So
So
she-
it was reviewed.
So it was
That's
reviewed,
what I
so
was
she
trying
didn't
to
go
do, buy
overseas.
some time so I can get back in front of the judge.
And the reason I say that is that it doesn't show in here that he has disobeyed a court order or done something, because there would have been something else amongst there that showed that. But what ended up happening is, you were telling the story that because this happened to your wife, the district attorney determined that there would be a charge brought against you, which was this one for the identity theft.
Well, they could not, I'm just telling you, and this is why I made national headlines, they could not come up with a charge. Because, and there was a case study down in Shelby County, and this is what the district attorney presented to us, was a gentleman was driving, had no driver's license, and no identity on him at all whatsoever to prove who he was or whatever. So he gave his son's date of birth, his name and everything. And because of that, he was let go, and he traveled on for it. And then later had gotten a wreck and had killed somebody. And they went back, and because that police officer remembered the name, they had went back to the son, and they tried to charge him, and that's what they did. And so they used that statute because that was used. Just because you say you're somebody, the way the law reads now, if you say you're John Brown, and John Brown goes and you go out and rob a bank, and they think of you John Brown, and your name is John Brown, you could get arrested. So just because you don't have to produce forms, social security numbers, tax records, whatever the case may be, just by you saying that is identity theft. So if you make a phone call and you say, this is Mr. Smith, I'm calling in regards to this piece of property across the street, you're committing identity theft now.
Yes, sir. And you answered no to a previous felony conviction on your application, and you've had identity theft.
You're absolutely right.
That's what I'm seeing in black and white.
But by the agreement with the district attorney in the state of Tennessee and myself, this was supposed to be turned over to a misdemeanor by 2012, and it was not. And that's what my attorneys are handling right now.
Explain.
The motion as amended by Commissioner Pearl does not have a second. So without a second, we're not in a discussion period of the motion.
Chairman Roberts, there is a background check here, and there's two Mr. Whitney's listed here. They're obviously two different people because there's a 14-year difference in age. The bottom one is designated with a star from staff, I'm sure, and this is Mr. L. Whitney. So I withdraw my motion because I do believe a background check in the state of Tennessee has been completed by staff, and again make the motion to approve his license.
I second that.
Second that? Okay. Discussion of the motion. Hearing none, chair calls for roll call vote.
A yes vote will be to approve the license. Commissioner Clayton?
Yes.
Commissioner Parr?
Yes.
Commissioner Pirtle?
Yes.
Commissioner Cullum?
Yes.
Commissioner Murray?
Yes.
Commissioner Trickett?
Yes.
Commissioner Bass?
No.
Commissioner Schaefer?
Yes.
Commissioner Webb?
No.
Commissioner Jackson?
Yes.
Commissioner Fox?
Yes.
Commissioner Roberts?
No.
You have a majority voting yes.
Mr. Whitney, you'll be granted a salesperson's license.
Thank you for your
Congratulations.
time. I appreciate it. Thank you.
Right. That concludes the appeals. There are no dealership appeals. We're ready for the director's report.
Been a rather busy quarter for the staff of the commission. The numbers in front of you have the dealers open or relocated at 135. That's 45 up from the quarter before. The dealers listed as 3940, 75 more dealers than there were in October. We've got 10 more applications in process. Seem like we get them by the dozens now instead of by the ones. We've had one more manufacturer get licensed since last quarter. They come up to 168, have the same number of auctions. There have been 6 additional representatives licensed in the state. And the most active category of license that we have are salespeople. 274 more salespeople this quarter than there were last quarter. And I went back a tad further than that. We've got 1,375 more salespeople today than we did in April of 12. So there's a lot more people trying to sell cars or selling. We've had 9 dismantlers licensed. The RVs and the manufacturers stayed the same. And there have been 6 show permits issued since last quarter. Might also add that I'd like to compliment our legal department for handling in a timely manner the large number of complaints that we get in a quarter and the backlog that we've had experienced for a certain period of time. Tony's making a hard push to get us reduction in numbers, and Miss Ryan is giving needed guidance on the formal hearings and litigation that's to occur. And as I indicated to you earlier, during the month of December, we're quite fortunate, the Motor Vehicle Commission is, in that we have been allocated 6 dates this year for an administrative law judge to hear our formal hearings, one of which was to be tomorrow. But keep in mind, if there's a proposed settlement that accomplishes something that would be accomplished at a formal hearing, we can get it accomplished beforehand, I think we're all better off for it. Now, it's not pleasing to me to have to notify you all on a Friday afternoon at the meeting on Tuesday that you've already made your reservation for and family plans for is a fact. But we're at the mercy of if, in fact, the other end of the lawsuit agrees to the proposition that's been offered. I mean, sometimes it doesn't come in a timely manner. But rest assured, I'll always alert you that if something comes up, I'll send an email and call you personally so you won't be stuck out on a limb for that extra day. But I certainly appreciate the cooperation and the spirit that each of you exhibit as willing to get to the bottom of all these issues that we have. That'll be it, Mr. Roberts.
Okay. Any questions for the director? Is there a motion to approve the director's report?
So moved, Mr. Chairman.
Moved by Commissioner Bass. Seconded by Commissioner Murray. All those in favor of approval of the director's report signify by saying aye.
Aye.
Those opposed? Hearing none, director's report is approved. Legal report.
Okay. Good morning. Thank you, Mr. Strickland, for those kind of comments. There was, in the legal review committee, there were 2 cases that there was amendments made to that I would like to go through now. Number 112, case number 2012-005671. There's 112th on there. The review committee recommended or approved the change of the authorized civil penalty amount to $1,000. The second amendment that was made was just a language amendment, which is number 119, case number 2011025821. Next to the last sentence where it indicates that a review of the line finds, indicating that a review of the law finds that the standard definition regarding curb stoning, that the word curb stoning is actually an industry term, and there is not a law regarding a definition of curb stoning, that statement will be made by, that is a statement that is made by legal counsel but not adopted by the commission in itself. Just for clarification so that persons don't come back and attempt to indicate that the commission has made a statement on a view that it would have. Other than that, Mr. Chairman, Ms. Robin Ryan had one other case that is not on the legal report that she presented to the committee, and this is the case that was scheduled for the formal hearing for tomorrow that has been continued because there was a settlement offer that was proposed Friday morning to the afternoon, and she would like to present that to the committee, to the commission, what was provided into the committee, which the committee adopted.
Ms. Ryan?
Before Attorney Ryan does it, we just had one correction on case number 31.
Yes.
The case file number needs to be corrected.
Yes, thank you. Case number
$1,000.
No, the case number 31 was separate.
Correction on the file number.
Oh, excuse me.
Yeah, they make that correction that the case number for number 31 should be 2012018701. Thank you, Mr. Jackson, for that.
I do have copies of the legal report on this particular case. If those who don't have it would like to have a copy of it. This matter was presently set to be heard tomorrow morning. In short, an investigation was done, and I'm going to summarize it. The legal committee already heard of it. You should hear all the facts as well. This was based on allegations against a particular dealer on various violations, including titles and other matters. And it was quite egregious sounding initially. And upon further investigation, it was discovered that there was an individual person involved who was in violation of the revenue laws. And as a result of the investigation, that particular person was arrested and was convicted of a fraud. I think he might have done that by agreement. But that person was also dismissed from the dealership. As this was originally presented for summary suspension, the dealer agreed to have the license suspended until we could investigate the entire matter. So the license has been in suspension since last August. And after we reviewed the entire matter, it was determined that there were 75 violations of excessive temporary tags and 65 open titles. And so the attorney and I, in reviewing the past recommendations of this commission, determined that $70,000, actually I discussed it with Mr. Leon Stribling and with Tony, the $70,000 would have been the appropriate civil penalty for that matter. And we have a provision in the final order that will say, agreed order that will say that this money has to be paid by the 14th of this month, or the license will be automatically revoked. But once the money has been paid, the suspension will be dissolved, and he will be allowed to go further at that point.
Thank you. Any questions from Ms. Ryan about this case? We would need a separate motion to approve this outside the approval of the Legal Review Committee before, am I right? I think we'd feel better. Would that be all right?
You certainly are welcome to do that if it makes you feel better. I don't necessarily know it's necessary, but it sure does make a cleaner record if that's what you're saying.
Let's do that. Your staff has done an awful lot of hard work, and I think that...
Let the, also, Chairman, the record, did you ever file a file number on this case?
I didn't, but I will amend it so that the minutes will reflect the file number on that. I did not bring that down, I apologize.
Any questions about this? We're not doing the legal review right now. We're doing this individual case. And we'll go back to legal review after this. Any questions about this case for staff or Mrs. Ryan?
Is it a franchise automobile deal?
I think the part of the spirit of this, Ms. Ryan, is to collect some money, get this dealer where he or she is licensed, bring them under our umbrella, if you will, and we can actually better, the commission can better monitor the activity of a licensed dealer than an unlicensed dealer.
Mr. Chairman?
Yes, sir.
Wouldn't it be more appropriate to have the committee submit it and approve it before you ask for another one? But otherwise, you're going to have the whole board approving it before the insurance committee did.
It was presented at the legal review committee.
It was.
I mean, well, excuse me, it was.
But we haven't approved the legal reviews committee and submitted that to the group yet.
Okay. So your question is as to the sequence of the approval. We could entertain a motion that way. If any motion will have to be entertained. If you want to make a motion to approve the legal review report and then move on to thumbs up, thumbs down. This one. So your motion is to approve the legal review report. Okay. We have a motion to approve legal review report.
Second. Commissioner Jackson.
All those in favor say aye.
Aye.
Any opposition? That's official. Now we're back to this particular case.
Then I'll move that we accept this case.
Okay.
We accepted it in the committee.
The motion is to for an agreed order with civil penalty of $70,000 in payment of court costs with a provision that if the agreed order is not satisfied by January 14th, 2013, the license will be revoked. Is that your motion?
Commissioner Jackson, second.
Second. All right. Let's do a roll call vote on this one, Mr. Chair. Yes means to approve the recommendation as I just read it.
right, let's see, Commissioner Fox,
Yes.
Commissioner Jackson,
Yes.
Commissioner Webb,
Yes.
Commissioner Schaefer,
Yes.
Commissioner Bass,
Yes.
Commissioner Trickett,
Yes.
Commissioner Murray,
Yes.
Commissioner Cullum,
Yes.
Commissioner Pirtle,
Yes.
Commissioner Parr,
Yes.
Commissioner Clayton,
Yes.
Chairman Roberts.
Yes.
Thank you.
Ms. Ryan, thank you for, that's a very complicated case and a lot of work.
You're welcome. Well, you'll have more to come.
Thank you. Thank you very much. And, Tony and Leon and Leslie, thank you for your hard work as well.
That being that would finish the legal portion.
Okay.
Other than you all, I know, like to keep up with my dealings in the National Guard, and I'm happy to say that as of January 1st, I was promoted from captain to major, and now I get to exchange armories. I get to drill here at state headquarters in Nashville. I believe as a budget officer, which doesn't sound like a thrilling job, but I'm sure it entails more than that.
Great, congratulations.
Congratulations.
We're all very proud of your service. Okay, old business. Staff, any old business?
I don't know how old it is, but it's been laying on the desk ever since you all got here. The conflict of interest statement.
Yes.
Go ahead if you would. Mr. Chairman, if you'd allow just about 30 seconds for each individual to sign it. Because
We'll do that.
I'm sure I'll be called this afternoon to see if I got them all. So please sign it, scoot it right out in front of you.
Do we need bullet points verbally on this, or?
Bullet points, each of us has signed enough conflict of statement, interest statements to know what it means. It means if you act out of line, you'll get chastised.
Bullet points noted.
Another thing, Mr. Chairman, if you all do not have a copy of the calendar, please get one. Take this back to the dealership and put it up on the wall. Because these are the days that we're going to meet. Now, the second day of each quarterly meeting has been set aside for a formal hearing, which Ms. Ryan will schedule. And please plan on being here 2 days, and I'll do my best to try to call you earlier, Commissioner Bass, on Friday. But we do have to go ahead and commit to those days because we've got a tremendous backlog of formal hearings, and by getting 6 days will to us this year, that was quite an accomplishment for our one board and many regulatory boards.
While we're on formal hearings, the next one is March the 4th and 5th.
No.
I'm sorry.
Correct. That's a formal hearing.
Formal hearing.
The single dates are formal hearings only, one in March and one in September.
Okay, so it's March the 4th.
That's March 4th.
All right, what time does that start?
It'll start at 9 a.m. and let me clarify something for you all. These are cases that are going to be presented before you on issues that might contain revocation or suspension. We've given permission for those cases concerning civil penalties alone to be heard before an ALJ. So we have 2 kinds of cases. While what you will be hearing are the kinds that have both, I also will be setting cases before an administrative law judge on the issue solely of civil penalties. So the ones that you will be hearing contain issues that could arise with suspension or revocation of license if proven. So those are the kinds of cases we'll be hearing. And I do have one set, or not will be set for the March date, and will be set for the rest of the dates this year.
The procedure of the ALJ hearing the civil fines only.
Civil penalties only.
Civil penalties only.
You had already previously given permission for those cases that don't concern the revocation or suspension of the license to be heard by an administrative law judge on the issue of civil penalties. So for those cases that have been presented to the respondent, wherein the respondent does not want to pay or has not talked to us about the civil penalties you already have suggested, those are the kinds of cases I will be bringing then before an ALJ alone.
9 o'clock, March the 4th.
Yes.
Hopefully back over David Crockett, but keep reading those urgent messages I said. Because sometimes they have require different parking spots.
That was my next question. Anything else on the roll of business? I have one item. At the last meeting, motion was made for the chair to develop an updated administrative license denial policy regarding felony convictions. I have had one conversation with Director Stribling and Tony, maybe I did. Separate conversations, but conversations. We're still developing that. I've not forgotten it, and I'll be making a committee assignment for that purpose. Okay. New business. Under new business, we have appointed the committees, subcommittees for January. I'm sorry, for 2013. Director Stribling is going to pass those out. We appreciate everyone's willingness to serve. I'll thank you in advance for your willingness to serve. And we'll have some assignments, some homework for you to do a little later.
Get bigger checks.
It doesn't pay extra either. Don't spend all this money in one place now. All right, is there any other?
Move to adjourn, Mr. Chairman.
Motion to adjourn. Second? Second? All those in favor of adjournment, say aye. Aye. All opposed? Meeting is adjourned. Thank you for your service.